Concerning
Mention a matter. Lordship was given me liberty to mention.
Inclusion.
No, Lordship had given me liberty to mention by this order, since the SLP was pending, the Supreme Court has rejected the defendant's application. Now the suit can proceed. This is the
For
order.
inclusion. Then for inclusion.
This is the order and this is the Supreme Court.
could I mention, my lord?
Do one thing. Keep yourself with the Supreme Court order. You return yourself. Next day, when it will come in the list, hand it over.
20
এগিয়ে না ওর তো এমনি delay করেছে। Let it come in the list so that the order can be taken into record.
Lordship is keeping it on any fixed.
I'll check.
Very well. Thank you.
I cannot commit any date right now.
Lord, could I mention a chamber application for final it will
For inclusion, coming into list, give it.
My lord, for inclusion for witness action, my lord, it was fixed on 25th November at 2 p.m., my lord, by the other bench, my lord, but matter could not be taken up.
For inclusion of this determination.
Yes, ma'am. Now, of course. My lord, kindly keeps it under the heading to be mentioned so that a date can be fixed, ma'am.
My lord, may I have my lord's kindly, my lord, to mention a company matter, my lord, for inclusion for hearing, lordship. This is being heard by Justice Bhattacharya. I mean, there is a direction of the, I have annexed the order also.
May I have your
Let it
lordship?
come in the list.
May I have your lordship's kind leave? Seeking leave to file my written statement, your lordship, by your lordships. I'm mentioning upon notice. This is the last order passed by your lordship, 19th December. By your lordship's order, your lordship had directed the suit to be transferred to the commercial division. Thereafter, your lordship, the plaintiffs have not taken out any fresh summons. Now, by your lordship's last order, your lordship
Let
had,
it come in the list.
your lordship, let it, I would have to file it in the department, your lordship. There is a view of the coordinate bench that the written statement has to be filed within 120 days. It is affirmed. The 120 days,
That's why I have to check. Let it come in the list.
let it come up tomorrow then, your lordship, because we have to file it in the department.
Right. Tomorrow. Tomorrow, day after tomorrow. Check it.
Your lordship, the time will expire, your lordship. I will have to get an endorsement by your lordship's officer so that I can
Tomorrow.
file
It
it in
will
the
come tomorrow.
department.
May I have your lordship can leave to mention very old matter, probate matter. In the year 2011, the probate was obtained, grant was obtained by the priest of the family, and that was
Now it's
subsequent.
for inclusion.
No, yes, my lord. That was challenged by the heirs and probate was revoked. Grant was revoked. Thereafter, my lord, 14 years already passed. No step has been taken.
So
Nothing
that means it is to be included in the list first.
for dismissal, your lordship. They have not
Let
taken
it
any
come in the
step.
list first.
Yes, my lord.
Lord, may I have your kind leave to mention one matter? My lord, this is with regard to item 21 of today's list, lordship's list. My lord, it's a witness action matter. It was specially fixed 2:30 p.m. However, my lord, Mr. Aurik Banerjee, who is the London Council appealing the matter, he has to attend WBLRTT pursuant to a division bench. Mr. Banerjee is there virtually, my lord.
Your
Kindly.
lordship, I am online. If you are
Who's
not
the other
online,
side?
your lordship, I am forced to mention this matter. I am mentioning upon notice.
Who is
Mr.
other
Atul
side?
Das is appearing.
All right.
Mr. Atul Das.
I have noted it.
Your lordship, Mr. Atul Das, only difficulty is that there is a division bench order pursuant to which the matter has been fixed here today and tomorrow before the
All right.
elected
You may
for
go
which I
there.
have
You
to
may
appear.
go there. I have noted.
I am grateful, your lordship.
All right. Date will be fixed later on.
I'm grateful, lord.
Grateful. Grateful.
May I mention for inclusion in the list for
I
witness
appear
action?
on behalf of the defendants. This is for witness action, my lord. I'm being led by Mr. AC Kaur, my lord. A date may be fixed, my lord.
Let it come in the list first.
Origin side, commercial division, item number 1.
May it please, my lord.
Yes, sir. So what is GA4?
Yes, I tell you, lordship. There was an application under Order 13 for a final decree. Well, that decree was passed.
You are plaintiff.
I'm for the plaintiff.
BB Poddar.
BP Poddar. Well, that final decree was passed in respect of the principal amount. It was on account of area rent. Well, we had also claimed interest. So far as the interest is concerned, it was kept for being considered later. Now, the decree provided the procedure for calculation of the principal amount. That has been done. The amount has been paid also by the judgment debtor. Now, the only prayer is, my lord, for interest.
GA4 is for that.
GA4 is for that.
Who is your other side?
for the
Affidavits are complete in the matter.
Have you got
Affidavits are
copy of this
complete.
application, exchange affidavit?
It's complete. Affidavits are complete.
we have don't have the
দেখো,
No, they've given us.
Have been complete.
We filed a reply also.
yes, affidavit in reply, affidavit in opposition, both are there.
Yes, all of them are
my
complete.
lord, kindly the
Either take proper instruction or don't appear.
It's for only the interest amount, my lord.
All right,
In fact, your lordship had directed it to appear today as for hearing.
I am appearing for the.
yes.
Well, it's not just only for the interest amount. There is already been a decree
Yes.
where the interest amount has been relegated to the suit.
That's what I want.
Relegated. How he has filed an application seeking a summary disposal.
Let me go through the application first.
Lordship. No evidence is required, my lord.
The evidence is required. We filed an affidavit to that extent.
No, we filed a reply also. It's only a question of calculation, my lord. Whether your lordship awards
Where is the
18%.
judgment?
Yes, it's at, I'll tell you, lordship. Well, it's dated 6th of February 2023. I'll
Page?
give you, lordship, the page. I'll give you, lordship.
18/6/2002.
Well, it's 6th February 2023. I remember. Oh, decree allow.
Which page?
Page 245,
Second volume to the.
volume 2. $245. And your lordship may could kindly turn to 257.
$257.
Lordship. In view of the above, the last paragraph, defendants are directed to assess the revised monthly as per the monthly rent should be as per the rent reasonable certificate along with the market rate submitted by the competent authority dated so and so, as well as the municipal tax provided by the KMC with effect from so and so till so and to pay the same to the plaintiff within 2 months from the date, decree be done accordingly. As regards the interest part, the same is relegated to the suit. So that's what I'm praying for, my lord. My interest calculation is at page 262.
And the suit may be heard out there.
Yes, that's what I'm
Let me
submitting.
go through this application. This is to be disposed of first.
Yes,
Page 262.
I'm praying for disposal of the suit in terms of, my lord, order 13,
The last
262. So, my lord, the principal amount has been paid. It was calculated and paid by the judgment debtor. Now, the only thing outstanding is the interest. In fact, your lordship had fixed today for hearing so that I could get my decree, final decree for the interest.
Today was 6 for the disposal of the application.
The application seeks, my lord, the decree. My lord, at page 262,
As regard the interest part,
yes,
same is relegated to the suit.
lordship.
Now,
I've
your point
taken a-
is that since it is relegated to the suit,
Yes, I've taken out the formal application, but kindly hear the suit.
Relegated to a suit, it can't be disposed of on the basis of an application.
because the interest should be at particular rate of interest, 1,
Yes.
2, 5, 10.
Now, that
Yes,
part
yes.
in our affidavit in opposition, if my lord sees, we also raised objection to the fact that.
No, just a minute. Let me understand one thing. You say it can be interest part can be disposed of.
Yes.
What should be the interest rate?
Well, lord, I have claimed at 18%, but it's up to your lordship. Well, lord, page 262,
Where you have claimed in the application.
yes. page 262.
Just a minute.
In the plaint, I've claimed at 18%. I've done the calculation for your lordship's kind consideration at 262. It's 2 crores 44
By the
lakhs.
application, you have mentioned that.
My lord, I have.
18%, para 9.
Lordship. And my lord, I've done
Petitioner
the
is entitled to sum of 24,459 so and so
lordship.
on account interest at a rate of 18% per
Yes,
annum.
and that calculation is at page 262. 262, the last page. It's only a question of the court's discretion now as to the percentage of interest or the rate of interest.
Page 262.
Lordship, the last annexure. We've done the calculation for your lordship's kind consideration at the rate of 18% per annum. So,
Now, why it is 18% per annum?
well, I'm claiming 18%. It's up to your lordship.
No agreement is there.
No agreement.
So that apart, my lord.
I will hear you. Just a minute. I will hear you. Definitely hear you. Let me understand certain basic facts.
Yes. Well, the rent was to be revised periodically, which they did not do so. Now, as a
Which
result,
para of the plaint you have claimed interest?
yes. I'll just tell you, lordship. Well, it
Para
begins
27.
it begins at page 9. I'll
No,
just
para 27.
of the plaint, my lord.
Plaint of the
paragraph.
plaint.
Page 35.
Page 35. Why interest? Is there any basis for interest or?
No, my lord, except that it's a debt due. It's a debt due, and so, my lord, I become entitled to interest. The question is the
So there is no agreed
rate of
amount of agreed
there
rate
is
of
no
interest.
agreement. There is no agreement.
This is your claim.
The rate of interest I leave to your lordship. But it's a debt due, not paid over a long period of time. Principal has now been paid pursuant to the earlier decree, my lord.
In the plaint, you have not specified any interest. Only said interest on judgment.
No, my lord, 18% at page 35. Lordship kindly takes page
Not in prayer.
prayer. There is a prayer, my lord, claiming interest also.
Prayer for interest, not specific
No,
rate
not
of interest.
specifically.
No, my lord.
Not specifically.
Sir,
But 18% is claimed. Yes. 18% is claimed at paragraph 27, page 30.
Yes, that is there. If taken together, it is 18%.
Yes.
Although not in prayer.
Lordship.
Your pleading is 18%.
Lordship. Well, lord,
So it can be
interest-
taken that you are claiming 18% on the basis of your this pleading.
Lordship. Well, it is always at the discretion of the court, my lord, as to what rate interest is awarded. Once a debt is ascertained, which it has been for pursuant to the earlier decree, once that that quantum is ascertained, well, 2 crores and odd was paid on the 30th of March 23 pursuant to the earlier.
When the property was vacated,
The property was subsequently vacated. Tell you, lordship. 2010, I think.
have you mentioned, where have you mentioned in the
Yes, I
application?
think it's mentioned, my lord. I'll just give your lordship that date. Seventh, 17th September. I'll just give you lordship that. Lordship just gives me a minute. Copy make it
2010.
2010. I think there's no.
We are claiming interest from 2006 when that rate was accepted.
2010, I think. Be back. There is no dispute that they have vacated the property.
All right. Now your objection, what are the objections?
We kindly see the affidavit in opposition. We kindly see. From paragraph D. Paragraph page 4. Paragraph 2D onwards.
Paragraph
2D. Page 4. May I place the specific paragraph?
The first point is basic trend could not be revised.
Yes.
We are not confronted with this question because this is decided fully and finally. Only part is interest part.
The question of interest comes in, where we have also alleged in the written statement that the delay has been caused at his instance.
That in para 9.
Yes, madam.
Para 10. That's there, para 10.
Delay has been caused. They have not given the documents. Apart from that, they have collected extra municipal taxes. In the account of municipal taxes, they have taken extra money, which amounts to about 3.5 crores. Whereas the actual corporation tax was about 59 or 54 lakhs. So these will come up when the point of interest will be decided, my lord. These will be the points that will be adjudged.
All right, let me go through these papers.
My lord keeps it on another day.
Yes. Hardy in part. Adjourned to 6th February.
6th February. My lord.
Grateful, my lord.
Great.
Item number 2, 3, and 4.
These are my application for injunctions. One is application for vacating.
Hardy possibly, partly.
The first time Lordship will be hearing us, Miller. I am enjoying an order, Miller. My management has a vacating application. The matter has to be heard out. Well, I am ready. I can start today, Miller.
Who is your other side?
But yesterday, I was not there yesterday for my personal difficulty. The interim order was still yesterday. That I heard from my learned friend Miller that Miller affidavits, directions for affidavits have been given. But I was not there. I have been told.
Well, it was mentioned at their instance because the interim order was. Let my learned friend make my submissions. He knows he was not there. So it was mentioned yesterday for extension of time to extension of the interim order, and also my lord, in that.
We shall know.
I know. Just tell me the dates. Yeah. That is the oppositions and the reply.
No, interim order is
No.
when opposition is 10 days.
Opposition is 10 days in what?
In both vacation of both parties, as well as the main, as well as the GA.
এটাকে স্টেপল করে দাও, ঝুলিয়ে রাখো না, একটা স্টেপল করে দাও।
আমি আসি।
Yes. I can start hearing.
My lord, I'll tell you. My lord, in the order 39 rule 1 and 2, the reply has not yet been made. That's why an extension was granted for 10 days yesterday. Thereafter, we have filed an order 39 rule 4, in which, my lord, the opposition has also not been filed. So they have been also.
Which is that application? GA number?
3 and 4, I believe.
Yes.
GA number?
GA number 2
Sorry.
is my injunction application.
Yes.
3 is their vacation.
2 and 3.
And GA4
3 is for
Miller 2 is
vacating application.
order 39 rule 1 and 2. 3 is for order 39 rule 4. Miller
4 is
for Miller application Miller for Miller extension of time Miller to take out the writ of summons.
J4.
These are the four.
My lord, in the order 39 rule 1 and 2 and GA4,
Exchange of affidavits are not yet complete.
no, and 10 days extension has been given yesterday. In the order 39 rule 4, the reply, the opposition is not complete. In that,
How long would you take?
my lord, 10 days already granted yesterday.
Already, my lord, 10 days
Orders have been
ওই order টা
passed.
কোথায়?
My lord, it has not yet been
not yet
uploaded in the
uploaded.
website.
The interim order has been extended till 6th.
So let it come on that date. That is 10 day means which is the next? Only 10 day.
10 day means,
days
my lord,
Date is not
take
fixed.
your lordship to 23rd, then to 3rd, hopefully 3rd. So 6th is fine.
6th, lordship keeps it on 6th, or lordship will keep it on any day prior to.
Let me do one thing. I am making it not today. Let it be uploaded. Let me get the order. Let it come tomorrow.
It's not necessary. I'll tell you, both the parties are not disputing it, my lord. Whatever has been the
Keeps it on
extension,
6th.
keeps it on 6th
6th February.
February.
6th দেখো।
Keeps it on 6th February, my lord.
Exchange of affidavit is yet to be complete. In GA2 of 24 and GA3 of 24. No, GA.com 2 24. Number গুলো দেখে নিও। And GA.com 3 of 24. Same shall be complete on or before the returnable date. Let the applications appear in the list on 6th February. It is extended till 6th.
Interim
Yes,
order is till
yes,
6th.
yes.
I am told, my lord. I
Yes,
was
6th
not-
yes,
February.
yes.
Check it. Come.
Yes, yes. Yes,
He is
sir.
saying, my lord, he
Yes,
is
sir.
he is on the
Yes, sir.
receiving end. my lord.
Yes, sir. Yes, sir.
My lord. My lord, in the first matter,
Mhm.
my lord, instead of 6th February, my lord can take it up on 7th February. I have some person. It is for the petition.
7th দেখো। 7th, okay, 7th
Grateful,
February.
my
Where will you go? Where will you go?
Because the fact is that the division bench order presided by Justice Devanshu Bhaskar, a matter has been fixed before LRTD every day from 2 p.m. So I have to go and appear. I am on
No
legs.
issue, no issue.
So that is the whole difficulty. Otherwise, I would not have. I am very sorry for.
I will check a date. I will give it.
I apologize for mentioning
No
this
issue.
matter. Otherwise,
Yes, item 5, you are here.
yes.
Item number 5 and 9.
Item number 5, your lordship remembers this is
Just a
a
minute.
partnership action
I appear for the plaintiff.
filed and petition for disbursement of certain money which were required for the medical treatment for kidney transplant of one of the partner, defendant number
Yes,
one.
I have heard it.
The lordship has refused
Yes,
to
my
pass
lord,
an interim order regarding disbursement of sum on 11th of December 2024,
Hmm.
from which we have preferred an appeal. The division bench took up the matter yesterday, and this was the order which was passed by the division bench.
My lord, your lordship has to hear the matter now.
One second,
There is
Mr.
no scope for-
Bhattacharya. I am not placing the matter on merits. Division bench has ordered that a sum of rupees 50 lakhs should be disbursed in my favor, and your lordship has directed us to file reply within 14 days.
Yes, my lord, may I file my
And your lordship will
an
kindly,
advance copy has been, an advance copy has already been
kindly
given.
allow me to make submission, then you give your reply. I'm not placing the matter on merits. And division bench has directed us to file a reply and to take up the matter after a fortnight. This is the order. So lordship will kindly fix the matter, and your lordship will kindly sees in the last page.
Already the order is there for disbursement.
Yes, and urgency has been recorded. Considering the urgency of the matter is to be taken up after a fortnight. So lordship will fix it after fortnight for hearing of the matter. Fortnight comes to on 28th of January.
Lordship,
Guided by-
I was appearing on behalf of respondent number 2 and 3 led by Mr. Utpal Bose, my lord, who is there
Hmm.
physically. My lord,
Yes.
only one thing, my lord, because of an injury to me, kindly instead of 2 weeks, kindly keeps it after 3 weeks, my
So
lord.
the direction of the division bench. Kindly
No,
see
There
that-
division bench, if there is division, I have to fix that.
No, there is no
Lordship,
time
fix that.
mentioned.
The
There is
urgency
no
has been
time.
recorded. It's the
Urgency
division
is
bench
there.
has considered the
I am
urgency
only,
because
there is
one
no
of the
time
partners
fixed.
is on
There is no
death bed.
time period
He
fixed by
needs a
the
second
division
kidney
bench.
transplant. So that's why this interim order has been passed.
There is no time period fixed. I'm only saying after 3 weeks, my lord. Any date after 3 weeks.
After the division bench order, don't say this. Don't say this after. There's no division bench order.
is directed to release 50 lakhs, which
We will-
was returned by him, my lord, pursuant to orders. of
Even
this-
thereafter, order has been passed.
and
Don't
order
don't
has
say
been
all
passed
this.
only on humanitarian grounds.
Don't say all this. You hate.
Today we really cannot fight over the merits of the matter. Let me file my affidavit in opposition. Advance
I'm not
copy
Mr.
has been
Mixer,
handed
so
over.
get your facts corrected.
My advance copy has already been given. Let me file my affidavit. My junior is there with the copy, my lord. Let it be kept on record. They can file their reply and the matter
In
can be
terms of
taken up.
order dated 13 January 2025, the learned division bench of this court directed that affidavit in reply shall be filed within a fortnight from the next date. Full stop. In terms of the order of the division bench, affidavit in reply shall be filed within the time frame as mentioned therein. Let the application appear in the list on 29 January.
My lord, I appear for the plaintiff. My lord, the opposition, a copy of the opposition has already been served. Let a copy be filed in court. My lord, let it be taken on record.
Affidavit in opposition.
Uh,
Affidavit in opposition filed on behalf of the respondent number 3 be kept in
no,
record.
no. Plaintiff, my lord, plaintiff. Yes, the respondent number 3.
Plaintiff number 3.
Plaintiff number 3, man.
Plaintiff number 3 be kept in record.
My lords, I appear for respondent 2 and 3, my lords. Our affidavit in opposition, my lords, we have been given an extension to file it within after paying cost of 10,000, my lords. We were also given directions to file affidavit in opposition, my lords, to the application. The division bench has extended our time by a week. Subject to payment of cost, my lords, we'll pay the cost.
Let it be paid, come next day.
Grateful, my lord.
Grateful.
Item number 6.
Yes, I heard it. Partly. I was hearing.
Sorry, my lord, in the earlier, both the applications should appear after a fortnight.
Both the applications. No. Let this application in terms of the direction. On that date, I will fix a date for other applications. Since this is in compliance with the division bench order, let it be so accordingly. Come on the next date. ঠিক আছে, এটা নিয়ে নাও।
ডাক হয়েছিল। Both were called together, that is why I thought that.
GA8 is a separate application for substitution. Has got nothing to do with this. Only for
GA8.
GA9.
This is in respect of GA9.
GA9.
GA9, ওটা GA9 এ দেখবে। Now this is GA8 you are speaking of.
Pending for 1.5 years. It has day for the original side. That the original takes 1.5 years from disposal.
Plaintiff number 1 means Mufajjilur Rahman.
Yes, that. And it's also a print of June.
Then 1A to 1F to be substituted.
And it's the paragraph.
Death certificate?
Hello?
Death certificate?
It's but that's admitted there. The please kindly see of the candidate order civil procedure order kindly civil order 22 rule 8.
Oh, the fact of death must be there. It is admitted.
The matter has for 1.5 years, and they appeared in the matter. This date is not disputed in a before appeal court also dispute regarding it. And was the legal representative that's also not disputed. One adjournments are being taken on different ground. First, some of them appear, some of them did not appear. They said notice this from all the legal representatives. Then court directed the court to issue notice to all the legal representatives. They mentioned in paragraph of the petition 6 legal representatives. We do. Who's done? Then court issued the notice. Received, recorded in order of court. Previously, court has sent, even then they did not appear, some of them did not appear. On that ground, adjournment was being taken. Court directed issue of notice by newspaper. We issued the notice in two English newspapers, Hindu and the Times of India, and one Hindi newspaper, and one Bengali newspaper. Huge expression. Then after the substitution, they came and took the order and got bunch of orders last year. That if the benches are one of the partners and in his place, who will be the partners of the plaintiff firm, that firm, the company, that we shall decide. Give us time, and then we make substitution. Totally irrelevant, totally a wrong approach to mislead the court. Not can you take off a good road? Can you take?
ওটা পার্ট তোমাকে ডিকটেশন দিলাম, বাকি পার্টটা পরে আসছে। ওপরে ওইটা পরেরটা উপরে লিখে রাখবে, দিস ইজ জিএ নাম্বার জিএ নাম্বার 8 of 23.
Whatever the social documents, and we take order 22 in A. A.
Duty of the pleader.
Hello?
Duty of the pleader to communicate.
The plaintiff pleader is to indicate what the legal representative. He did not do so. Thus, breach of duty on his part. But they are cousins and petitioner we know. You are in the paragraph 8, you set out the list of widow, son, two sons, two daughters. What is to regarding that? Now, they take that, and upon the death of a party, who will be substituted? Legal representatives and not the partners. Can you take order 22, rule 3? Can you take?
Question is right to sue survive, whether right to sue survives or not.
No dispute. Yes, you see the order? No, no. The plaintiff, I am the plaintiff has filed the suit. I have filed a counterclaim in the state. Our case is the partnership firm has to dissolve, and that is supported an order of Master Justice Article 40 single arbitrator in a proceeding under Arbitration Act. Yet it is a partnership at the win. And mutual resolution given by my client, that means. And yet on that reasoning, he has terminated the arbitration. That order is not challenged anymore. So, after resolution, whatever case may, now I have got a claim against all the plaintiffs who are the erstwhile partners, including a deceased one. Deceased plaintiff. Now, his estate will be liable. He has not paid my share of profits. My share of profits. So, who will substitute? The legal representative. Legal representative. The court is no affidavit. See, the order is passed. See, I have a bunch of orders. But because I tell you that nobody is arguing the right to sue doesn't satisfy, right? Argument to something else. Let them know and not clear. Argument here and now, and that's the word. Whatever argument there. So, more than half year, no affidavit is filed. No matter is being clear. And then can you dispose of the matter without by such order? Order 22 states when owner promotes the plaintiff died and right to survive, doesn't survive, the surviving plaintiff or the plaintiff alone, or a sole plaintiff or a sole surviving plaintiff dies and right to survive, or an application made in that behalf shall cause the legal representatives of the deceased plaintiff to be part. With intent. Normal calendar order rule 4 also. He is also dependent. If my counterclaim, he is also a dependent. This is dependent. Well, one of two more dependent right, and I to the same language, dependence alone or dependent will right to separate both have been made on that year for the legal representatives of the deceased dependent. Who is the legal representative? Is defined. And you see, section 2, 11, subsection 11. Whether you answer, but how is it relevant? It's not relevant. On the issue method, section 2, 11, legal representative means was the partner or non-partner?
Which paragraph?
Section 2, subsection 11.
Estate of the deceased person.
He can represent estate of deceased person. So whether the partner, there are 6 legal representatives. Of the 5, paragraph 10 to paragraph 8, no? Okay, you have to keep the list. Paragraph 6, we have 3 daughters, 2 sons, and a wife. They are legal estate. Now, under the partnership deed, partnership and dissolve backward in basket. Even if partnership survives, it is for them to decide out of these 6 legal representatives who will be the partners. Let them decide. Doesn't matter. Provision of law is not, if a partner dies, then the partner replacing him should be substituted. A person dies, partner, whatever he may be, his legal representatives are to be substituted. On that plea, matter will either give another larger charge. On that plea. Now we'll come to your lordship below, and we are thankful for that. And lordship dispose of the application. He the below of that earlier order on what counts as delaying matter. 1 year, 6 months have passed. Application of substitution pending. They're delaying the matter. But the suit cannot be heard. They appear and what was the 3 days second? Not the suit can survive in English. That is not where ever happened. Paragraph. District second paragraph. 16th October. 16th October 23. Kapoor, lecturing on the submit of the description mentioned in paragraph 8. There are altogether 6 legal heirs and of the plaintiff admitted. And as per clause 9 of the partnership, maximum 3 legal heirs in partner can be included on the That's for them. How is that relevant? Or substitution application? Then we are on that cover natural delay. And how they submit no just says understand what not correctly assisted on that. After that, no, they did not decide for 6 months. Then 7 December matter came up.
এই অর্ডার গুলো আছে কিনা দেখেন আপনার এই সবকটা অর্ডার আছে
Lord, may I suggest this? The other matter has been kept on us another date. If this can be tagged with that, there is no urgency as such.
Strongly upon this submission.
Yes, Mr. Mitra, let me hear Mr. Mitra then.
Substitution pending for 1 year, 6 months. Can you imagine that original side? It's a sad day for the original side.
Yes.
All this, my lord, all of us know how long, my lord, applications are kept pending. There is no point in saying that, my lord, it is a sad day for the original side. Now, my lord, it is not pending for 1 year, 6 months. No. Emphatic no. My learned friend has not said when was this application taken up. Now, secondly, now, my lord, it has been pending for 1 year, 6 months. According to them, according to me, it's not. It was on the applicant to serve on all the legal heirs. When did they complete the service? Kindly look into your lordship's record, my lord. Your lordship passed order, my lord, directing service. It's no other honorable judge, my lord. It is your lordship who was, my lord, dealing with this matter for quite some time. Now, my lord, on the last occasion, or my lord, the occasion before, your lordship was pleased to grant me leave, my lord, to file affidavit. Now, my lord, the affidavit could not be made ready. I would, my lord, seek for, my lord, some extension because the other application has been kept after 2 weeks. I would seek for an extension, my lord, of 1 week, my lord. They are not required to file any reply possibly also. It can be taken up today. Now, the other...
I can allow you 1 week time. If it cannot be filed, it will be deemed there is nothing to be opposed.
My lord, only thing is, my lord, my learned friend has said that, my lord, he has counterclaim against, my lord, the individual partners.
I'm not going into that. I'm not going into that. We are concerned with this application only. An extension of time is sought for
not reply. That is just, I have just said only the applicant will be. It's a matter of
Sir, we are not concerned with this right now. It is to be disposed of.
In August.
Even if it is delayed,
It's in August, not in June.
whatever that might be, let us concern with this application. Let us proceed with the application.
this order record. Can you see the order? Okay.
All right, we are not going into that. Let the order, this will be processed properly. কি বললাম? By Mr. Mitro, the learned senior counsel appearing for, year for?
My lord, the legal heir of my lord.
Plaintiff one. Mafazul Rehbar.
Legal heirs of the plaintiff number one. কি বললাম লাইনটা?
Legal representative.
Legal representatives. Okay. কি বললাম?
Yes, all legal. Yeah, no, yes, different. That's true. Say yes, all legal representative. Yes, all.
This is plaintiff number one.
Yeah.
Full stop. The matter is full stop. The matter is pending for long. Time to file affidavit in opposition. 1 week time is allowed. 1 week time is allowed to file affidavit in opposition. Semicolon. Affidavit in reply shall be filed within 1 week thereafter. Let the application namely GA. This should be GA Com 8, commercial matter. GA 8 of 23 appear in the list. ওই কবে ডেটটা দেখলাম? 29 January. No further time shall be allowed for filing affidavit, for exchange of affidavits.
Grateful. Grateful.
Supplementary affidavit filed on behalf of defendant number one be kept in record.
Item number 6.
Madam, for the plaintiff. Lordship was hearing the defendant.
I had started facing the arguments that had covered the issue of regards to
Your point was there is no in the application when you file application for trademark, they have no specific mention that the word duro should be protected.
I also said at the point in time when the registration was sought by a company called Sharda, and there was no connection between Sharda and the plaintiff's choice of the word duro. In the various applications that we had also made for the trademark industry, the applications were all in part B, because at that point in time there were two parts of the register, part A and part B. For being able to get an application in part A, you had to show distinctiveness, and that was what was not shown, and therefore registration was in part B.
You could adjust for the
Therefore, the registration was made in part B. And then with regards to Millet, the registration of part B, all the applications, Millet, which they had sought registration of, had duro as part of their mark. And there is no, so therefore, Millet, duro was always a Latin word, which meant tehad.
That means a general word.
Generic. That it was a generic word. And I had also shown, my lord, one such application of theirs.
So your point is that a generic
duro
word
was disclaimed by the trademark registry, to which they have no opposition. So as on this day, they cannot seek any right on the word duro simpliciter, and all that they can seek registration or protection of is their combination of marks. Duro ply if they have, duro, etc., duro board, duro marine, whatever they have, they can seek registration or protection to that extent and not prevent everybody all in sundry from using the word duro. Now, second, I had also shown, my lord, that the word simpliciter duro, they had applied for registration. The registry, for whatsoever reasons, had declined registration. And that registration which was declined was made soon after the change in the Trademark Act. So, as on that day also, there was no distinctiveness which they could show, and therefore they did not get registration of the duro mark simpliciter. So, all that they have is duro marine, duro board, etc., etc., and this is what they have proceeded with. Now, that my third leg was of argument was that the prayer that they have made. We'll kindly have a look at the injunction application for once. And I had also shown, my lord, that as on this day, the Duro Ply, my lord, has given all its rights to Shujoy. Shujoy, my lord, has there was time limit. The license agreement was time bound. It has expired by efflux of time. So as on this day, Duro has nothing to do with these marks. Now, I had also I'll invite my lord's attention towards the prayers made in this application. Will we kindly have a look at the prayers in the injunction application, page 34, 35 minute. Now, the prayers have been framed to read as the respondent and or each of its manufacturers, licensees, men servants, agents, assigns, directors, partners, employees, dealers, or anyone acting on its behalf and claiming through it be restrained from marketing, manufacturing, distributing, selling in or advertising in print or electronic media or on the internet or otherwise, etc., etc., in plywoods, teak plywood, etc., the nature of goods. Then Millard will see under the mark Duro Touch or Duro or any other mark which is identical or deceptively similar to the petitioner's registered trademark Duro marks. Now, Duro was never registered and Duro has been disclaimed by them. So that this prayer, what they have not been able to achieve from the registry, they are making this application and trying to get an order saying that Duro cannot be used by anybody, which cannot be done because Duro has been disclaimed and Duro is a generic word.
But only one thing, letter, only she can indicate which page Duro has been disclaimed. Which
yes, in my opposition, I have
kindly,
yes,
kindly,
I had on the last occasion showed, my lord.
Yes.
Once again, I will show. Definitely,
Opposition. Just that.
Yes. Then will kindly take page 162. Of my affidavit in opposition. Yes, that page. So, will kindly see the mark they had sought for registration was the Duro in small and Puma then was the mark which they were seeking registration. Now, we'll see the date of application, etc. 1990 is the date of application. Then comes the nature of goods. Then will see registration of this trademark shall have no right to the exclusive use of the expression Duro appearing on the label. And also, I'd also shown from their application that the various Duro marks that they are seeking registration on, all are in different nature.
You have mentioned this in the notes of argument?
Yes, everything is mentioned in my notes of arguments. All of it, I've indicated the page numbers also, and I've also indicated everything from my opposition. And I've even set out these sections of the old Act, section 9 and 11, for the purposes of when Part A registration is granted, when Part B registration is granted. But I have also for the purpose making it a little convenient for my lords. In my written notes, I've only taken out those pages from my learned friend's application.
Which are
where
relevant.
Duro, will have a look at the pages. These were the pages from their application where Duro has been indicated by them.
This is in the notes of argument.
Yes, I've mentioned all of it in my notes of arguments. With what is the mark that they have been using all along? What is the mark that they've got registration of? That everything has been mentioned.
All right. Okay. Any reply?
Then I had also shown 2-3 judgments on that day, and after the judgment, I have more other points which I've indicated in my written notes of arguments also, that they have shown numerous marks, and to show that they have been there existing in the market, and by Duro, it is only they who are, it prompts them, and therefore they have shown lots of pages from the internet from where usage of such mark is indicated. By that, Duro only means Sharda Plywood or Duro Ply Industries and nobody else. That all these pages which they have annexed to their application that are all the search engines which show not only show their Duro but also shows Duro volume 2. Also shows the Duro of other users in Nepal, etc. We will kindly have a look at pages. Let us come to
of your notes of argument.
No, of the application, volume 2. With volume 2, they have tried to indicate that this is how they have been using words, Duro. And it's quite popular. Annexure I, page 168 onwards. With all of it are, if my lord has a look, these are their annual reports. But of course, my annual report will speak only about me and not about anybody else in the market. At page 177, we'll see 172. This is their press release. Their press release will always indicate them. And even in the caution notice, which is mentioned here, we will kindly have a look at page 204 for one moment. They've put down all their different types in which they represent their word. We will kindly have a look first. Sharda Duroply. This is how they represent themselves. Duro board. Look, everywhere Sharda or Duro has been indicated. So this is how they represent themselves. Now I will take my lord to my mark. I am Duro Touch equally registered. Then we'll see my mark, which is at page, my application at page 46 of my affidavit in opposition. This is my mark, Duro Touch.
Page
46 minute. This is my mark, Duro Touch. Now when it comes usage of their marks, they say that they've been using it for a long, long time. And for that purpose, they have annexed a few invoices. But if I may take my lords through the invoices, I have been able to the earliest Duro Touch or Duro Ply all along when Mr. Ghosh was addressing my lord, but he was concentrating only on Duro Ply. But all along, all these invoices, now take any invoice, for an example, I will show page 132 of their application. Any one invoice, if I take
which
volume 2, volume 2, the first invoice they have indicated, they've annexed, which is the earliest in time, is at page 127. 127, volume 2. This is the invoice of Sharda Plywood, because till that time, Sharda Plywood had not been changed into Duro Plywood. Now we'll see, date is 9/7/76. Now this invoice does not mention of any brand. It only mentions of plywood. It can be of any company, any plywood whatsoever.
So you want to stress that there is no long time use.
There is user, but then there is user of what? I'll show the of the indicator, the mark of which user is there. Now 128 Tiger brand. 129 is Duro Teak. Then it comes Duro Puma Ply 130. 132 Duro Puma Ply. Here is Duro Ply. The
So your point is there is no long user.
There is, There might be long user, but they cannot come and say that, no, I am preventing you from using the mark. But this invoice is of 88, but the good which is being sold is Puma ply and not Europly. We'll see.
Why did you use the term duro? The word duro.
Yes, duro, I definitely, it means hard. It is a term which is used with ply. If it comes for durable. That is the reason why they have been attracted to use the mark duro. Otherwise, why will Sharda use duro? The question which Mr. Ghosh had posed earlier on while addressing, he said that you are Ma Mansha. I would have understood if you had something to do with Mansha. But then, same question is posed to him. He was Sharda all along. In 2005, he has changed his name from Sharda to Duroply. So why, what attracted him to the mark Duro is only because it was for hard, resistant to the ply is resistant. Duro marine, the ply is resistant to be able to take the whatever acts of even water. So that is the only intention of them using Duro was because of the descriptiveness, because of the indication which the mark would have brought, not anything else.
All right. How do you next step? Any reply?
No, a few judgments, which I had all are annexed in my application. I had on the last day indicated Ultratech cement, which I had indicated that I
will go through this.
All lists I will indicate. I will share with him all the judgments and the citations. He can then
Study part adjourned to
and also I have dealt with his judgments also in my written notes of
28/9. 31st January.
31st January, yes. Oh, I'm sorry, 31st I'm in some difficulty. May this be if not 31st, thereafter.
Which one you tell me?
5th February, if it so commences to my lord.
5th February.
5th February. Thank you, Baba.
Copy judgment को तो दे दीजिए आवाज judgment को तो दे दीजिए फोटो पूरा दिए को
Item number 7 and 8.
The deed is supposed to be placed in this court.
Lordship.
The deed is supposed to be placed.
The last occasion I find here, my lord was pleased to direct the registrar original side to cause an inquiry and file a report. When he looks to my lord's last order, my lord. So far as official receiver, when the report is already there, that deed is copy is not available in the office one.
So it could not be traced. The same thing is repeated. So let me pass an order directing the registrar original site at the cost of the High Court. Certified copy of the deed may be obtained. That will operate as an original deed. Since it is now on record that it is lost, so that will be treated as an original. So if any order is passed in the favor redeeming the mortgage, that will have to be given. Whoever that might be.
Your lordship will decide, my lord, who has the right, my lord, to
Let it come. I will decide it. The report of the learned registrar original site dated 2nd January 2025 along with the report dated 9 December 2024. Have you got the copies of this report?
No. I was just praying for that.
Are perused. Full stop. Copies of the report may be handed over to the learned counsels. Full stop. It is made clear in the earlier report dated 9/12/2024 that title deed in question could not be traced out in spite of extensive search either from the office of the official receiver or from the office of the court liquidator. Part of this report is noted.
Particulars of the deed are not mentioned. That certified copy cannot be obtained. Particularly the book number, volume number, etc. are to be mentioned. Otherwise, my lord, impossible job, my lord. Is
Is not mentioned earlier.
Mentioned that the department will find that out.
Why is
We
it going to find it?
Deed of mortgage dated 12/12/1944.
কি করে ফাইন করবে 44 সালে ডিড অফিস থানায় আছে হ্যাঁ তো চাইছি কোন দলিলটা চাইছে ডিড অফ মর্টগেজ কোথায় we have in connection with the application, my lord. I'm told, my lord. I have a
And what about the title deed?
title deed. I cannot see.
Can you give a particulars of the title deed?
Yes, my lord, we can. I think my learned friend has.
If any copy is available, my lord, the numbers can be obtained from there. The book number, volume number, and page numbers.
My learned friend has.
Let him deposit the same, my lord, before the court, my lord. Then, my lord, it will be easier. It will be easier and impossible. Impossible. Otherwise, it won't be possible.
We have certified copies of both the dates.
Give copies.
I'll give copy.
Yes.
These certified copies will be obtained by the High Court because it is in the custody of the High Court. Give the just copies accompanying the supplementary affidavit.
Otherwise, my lord, possible.
I'll file next date. I'll file a supplementary affidavit with both the copies.
Let that direction be passed, my lord, upon that.
Mr. Bose, the learned counsel appearing for
Applicant in J number 3 of 2023.
applicant in J number 3 of 2023.
Yes.
Defendant applicant. Yes.
But the
Defendant in
applicant
the suit.
থাক
Yes.
আবার সুতে
Not substituted defendant.
আবার এই বলে
Applicant in defendant 3 in GA3,
applicant in J3 of 2020.
namely Mr. Pradeep Nahar.
Who has been substituted as the defendant.
Namely Mr. Pradeep Nahar submitted that by way of supplementary affidavit, copies of the deed of mortgage as well as the title deed will be produced on the returnable date. Let the same be filed on or before the returnable date. The matter will appear in the list on 17th February.
My lord, 29th.
How long would you take?
One.
I have a lot of other matters.
48 hours or 72 hours, my lord. That's reasonable. Some early 29th January or 30th January. If possible, my lord.
20th January, I'm fixing it. You file it, further order I'll pass. 20th January.
And my lord, there is short notes on behalf
Keep it with you right now.
right now.
For hearing of the application, I will take help of these notes.
And my register be directed to serve a copy of the.
That is passed. That
Passed.
order is passed.
Register will serve because nobody is appearing for the register.
No, not register. Why register will appear?
No, but some
The
council.
court officers will give a copy.
The court officers can be obtained from the court. My lord's court
Yes.
officer.
Copy may be given by the learned register, original side.
Office of the
ওইখানে দিলাম না, copies of the may be given by the learned register.
office থেকে দিয়ে দেবে
Item number 10. Commercial division, item number 10.
Issues for framing of issues.
This is the first issue on behalf of the plaintiff, my lord. I am from the plaintiff. It is the-
Who is for the defendant?
Well, I appear for the defendant numbers 2, 3, and
Issues are
4.
there.
Yes, my suggested issues are.
চেক করে নাও WS আছে কিনা। Plain WS, any counterclaim?
No.
Party devi chamber. I'll frame issues.
Very well.
Tentative date for witness action.
It's for the plaintiff to adduce their witness.
February, that is convenient.
I'll check the date then. February, you say February.
Witness action.
Great.
Item number 12.
I was cross-examining.
Kapil Dev Chaudhary. Kapil Deo Chou Bhary.
Cross. Does the plaintiff company use any accounting software for maintaining the accounts?
Yes.
Can you tell my lord which is the software that is used by the plaintiff company for maintaining such accounts?
It's Tally Prime accounting software. Tally.
Chamber party.
Shown Exhibit H. Has this ledger of the defendant printed out LEDGER ledger of the defendant maintained by the plaintiff printed out from the same software that you are referring to?
Yes.
Is your answer same for exhibits I and J?
Yes.
Shown exhibit K. Has this ledger for the period 1st April 2013 to 31st of March 2014 also taken out and or printed using the same software referred by you?
It has been downloaded from software in Excel format and thereafter printed.
Why is I suggest to you that the difference in the formats of exhibits H to J and in exhibit K is because exhibit K has been manufactured by the plaintiff and not taken out from the software referred to.
Has been downloaded from software in Excel format and thereafter Name and period has been written. Name and period has been written.
So, is it your evidence that in the downloaded copy in Exhibit K, the name and can you repeat the answer?
Address.
Question type by repeat. Next question.
Your evidence that in the downloaded copy in Excel, Exhibit K, the name and
The period has been filled in by the plaintiff after
মোবাইল লাইটটা অফ করতে বল, লাইটটা জ্বালিয়ে রেখেছে কেন?
downloading the ledger from the
Put
software.
your handset in your pocket.
Yes, period mentioned in headline has been written.
Mentioned in headline has been written.
Yes.
I suggest to you in the accounting software as referred by you, the name and the years period do not require to be separately filled in but are automatically generated.
Yes, but we have to put address.
Shown Exhibit F. No, just one more question before that. Is your answers from the above in respect of Exhibit K same for exhibits L2O? The nature of the documents are similar, so I'm not putting separately. L2O.
Yes.
Shown Exhibit F. What is this document?
Check issued by SNG Fashions Private Limited in SNG Fashions Private Limited
SNG Fashions Private
in favor of Starlight Vyapar Private Limited.
Starlight Vyapar Private Limited. Starlight Vyapar VY.
Can you tell what is the date of this check?
23rd March 2017.
Can you please tell what is the account number and the check number?
Check number 231670. Account number 083705001705. Yes.
Your Lordship, I wanted to refer to the affidavit in opposition filed in GA1, but that is not before Your Lordship because the suit is only appearing. So if Your Lordship can pass a direction, since I am ex parte, Lordship, I just wanted to put a couple of questions from the opposition filed by me.
All right, I am adjourning it today.
Lordship.
Let the opposition full record be placed in the court. You may refer any document. Is PW1?
Yes, Your Lordship.
PW1 is partly cross-examined. Adjourn to Disbursement. 10th February for further cross-examination. Record of the suit may be placed before this court on that date.
Lordship, any day before or after 10th, my learned advocate on record has some problem.
13th?
Grateful, Lordship.
Lordship, item 13, I beg to appear on behalf of the plaintiff.
Witness is there? Witness
The
is there?
second witness is at a personal difficulty due to his health. And
Adjourn to
my lord, I'm praying for a time of 3 weeks.
14th February. For witness action.
Grateful, man.
Lordship.
Item 14.
Yes, J8 and 9. Who is your other side?
My lord, for the respondent, my lord, I am being led by my senior, Mr. Shantan Bose. He is logged in virtually.
What is J8?
J8 is the substitution application. The plaintiff is died. And this substitution application has abated by 1 day. For that reason, the file GM9 that is for setting aside of the abatement.
Where is Mr. Bush?
My lord, he is logged in virtually.
Come tomorrow. Not today.
Can be kept on Thursday instead of tomorrow. Thursday or Friday.
All right. It is taken you.
Malad, I am there, Malad. Malad, I am there. It can be taken up.
Oh, he's there.
Have you any objection?
Yes, Malad, to the abatement application, because your lordship will see the conduct has to be looked into. It is not only a matter of 1 day. Kindly allow, to the setting aside of abatement application, I would like to file an affidavit.
You want to fight affidavit?
To that, or Malad, I can argue this application also, then your lordship will keep this for hearing because there is no explanation for the delay. They file
You
the
like to file an affidavit?
I would, Malad.
Mr. Bose, the learned counsel appearing for the defendant.
Defendant.
Yes, my lord.
Defendant. Please leave to file affidavit in opposition. Full stop. Affidavit in opposition shall be filed within 2 weeks. Semicolon affidavit in reply, if any, within 1 week thereafter. Let the matter appear in the list. 17th February.
Obliged to you.
Grateful, my lord.
Regular list. Item number 1.
My lord, I appear for the plaintiff.
Order was passed in this case. Judgment or decree was passed.
Yes, decree was passed in 2 suits. Now, my lord, so far as CS 42 of 2006 is concerned, my lord, some of the records were untraceable. Hence, my lord, in respect of GA 8 of 2020, which was filed in CS 42. Now, lordship directed on 19th of December, the registrar original side to intimate whether the affidavit in
does not show filing of AO in GA 481. Does not show filing. It is, if it is lost, it could be reconstructed.
Yes.
Why this application is needed?
No, my lord, no. GA, what was GA 8?
What is your GA 8?
Yes. Yes, my lord, I'll tell you, lordship, my lord. Eviction suit filed, eviction decree was passed. Then, my lord, a reference coppens before the special referee.
Yes, that was also allowed.
Yes. Now, my lord.
Decree was to be drawn up now.
Yes. Now, for drawing up the decree, Malad, the record of GA 481 of 2020, which was renumbered as GA 8 of 2020, was required. Malad, that Malad, we inquired and it was not, department
It
said
is not filed. It was not filed.
it was not filed. Then Malad,
The report of the learned registrar original site dated 13 January 2025 be kept in record. Full stop. It is stated that there is no record of filing affidavit in opposition in old GA number 481 of 2020, comma, newly numbered as GA 8 of 2020. GA 8 is supposed to be disposed of.
but GA, everything was disposed of because Lordship ultimately decreed the suit by your Lordship's judgment of 6th of October 2023. Now, Lord, so
Let
far
the
as
same report be kept in record. Decree may be drawn up.
grateful. Malad.
Yes, where is Mr. Banerjee?
It's coming.
Pass over.
Item number 3.
3, my lord, I appear for the plaintiff.
All right. Mr. Banerjee has come.
Item number 2.
Why can't you come in time?
Come from 4 to 26. 26.
Yes.
Lord, pursuant to your Lordship's order of 7th October 2024, now this is my report. May I kindly hand up? Lord?
List of tenants shall be handed over to Kolkata Municipal Corporation.
Yes.
Was
We
it
had
done?
approached them, but they wanted us to make certain changes in the list that we have made. I was expecting the learned advocate to be present, Miller, here now, but we will give it in the course of the day. If your Lordship kindly takes up the report which I have handed up.
None appears for Kolkata Municipal Corporation. Full stop. In the previous order, dated 7/10/2024, direction was given
Lord, my learned friend is there, not appearing for the Kolkata Municipal Corporation. May I hand up, Miller, the list of the tenants to him?
the line indicated in. List of tenants is handed over by Mr. Banerjee and Mr. Dave to the learned counsel for Kolkata Municipal Corporation. Area wise, let me see the copy. Let a copy of the report be kept.
Look, I'm handing up the original to the court. I'll give it to my learned friend, and I also have a
Where is the
copy
original?
of the court. Your Lordship, Miller, can keep the copy which I've handed up to your Lordship, Miller, as the records of this matter. I've given one more to my learned.
All right. List of tenants, comma, as on the month of January 2025 is filed by Mr. Banerjee and Mr. Dey. Let the same be kept in record. A copy of the list is also handed over to the learned counsel for the corporation, Kolkata Municipal Corporation. Full stop. Let proportionate share of tax be assessed by Kolkata Municipal Corporation in respect of each of the tenants. The same report shall be submitted before this court honor, submitted in this court honor before the returnable date. Full stop. Eta rekhe dao. Mr. Banerjee also submitted a report.
Your Lordship's query in the order of October 7, 2024 was whether the quotation which we had initially given of Ajanta Construction was the lowest quotation or not. After your Lordship had passed the order, we had taken 2 further quotations, which will appear from pages 17 and 18. And these quotations, Willard, are higher than the amount of 12,50,000.
It is in the report that further quotations were called for from the contractors and chartered engineers. in response of which two other contenders, comma, as mentioned in the report, submitted their estimate, which is higher than Ajanta Construction. Which is much higher, লিখুন। Full stop. In view of that, work may be finalized with Mrs. Ajanta Construction to proceed with the repairing works as per their estimation, namely 12,50,000. Necessary payments may be made out of the common fund.
Not estate fund.
Estate fund. Let the report be submitted. What will be the time frame?
Lord, they intend to complete the work by March. May I hand up one additional report, which I have recently
Full
prepared?
stop. An additional report is filed.
Yeah, because I need to make some submission based on my additional report. If your lordship kindly takes up the additional report.
Is also filed by Mr. Banerjee,
Lord,
dated 14/1/2025.
Page 4 is an email which I received from Ajanta Construction, Mr. Dasgupta. He is Milad the personal engaged. If your lordship kindly takes
Full
up
stop.
page 5.
If any obstruction is created in progress of the work, the learned receiver shall forthwith inform this to the court.
Lord, I have through this particular report.
Okay, line indicated in. Mr. Bosch, in terms of the report, inform that.
Paragraph 5.
Yes, I've seen Mrs. J. Carew and Miss V. Carew created obstruction in the progress of work of renovation. Full stop. The said tenants must raise their objection before this court within 7 days. In absence of which, it will be deemed that they had nothing to object to the progress of work. And it will be further deemed that.
Milord, I don't intend to interject. But may I kindly make one submission? What they are saying is, they want a kitchen to be built, which was.
All right, they will raise it here.
Milord, they have given me a letter, which is at page 6. To this, neither Mr. Day nor I could agree. Because they want, Milord, a kitchen.
Let them come to this court.
I'll intimate your lordship, sir.
কি বললাম? আচ্ছা, ওই ফার্দার ডিম কথাটা কেটে দিন। No objection shall be entertained by any of the tenant unless made before this court. Any interference or obstruction, any work of the learned joint, you are joint receivers.
No, I am the receiver, Milord. Mr. Day is assisting me in the workmanship of receiver.
The learned receiver shall be deemed to be interference with the function of this court. A copy of this order may be communicated to all the tenants by Mr. Banerjee. Let the matter appear in the list. On 24th April, with liberty to mention.
24th April.
Only one thing, may I say, my lord, your lordship's last order dated 18th December, your lordship directed the corporation for regularizing the assessment record. And now, my lord, your lordship, if I am actually correctly here, that the percentage of actually assessment, because my lord, 3.5 square feet, it is very difficult to actually apportion that taxes of the tenant. My lord, record
আচ্ছা,
can be
এখানে আরেকটা
actually,
কথা লিখে দাও একটু
my
নিয়ে
lord,
নিয়ে তো।
that will be creating problem. 3.5 square feet, one is possessing for 35 rupees.
What can I?
Whatever
that
that
is-
might be,
that is
that
why
is to be ascertained. Even it is 1%, that is to be
that-
ascertained.
My lord, just
কি বললাম ওখানে প্রথম দিকে লাইনটা বললাম
do
অ্যাসেসমেন্ট অফ ট্যাক্স বলেছি না কলকাতা মিউনিসিপাল কর্পোরেশন আর ফার্দার a detailed report shall be submitted fixing responsibility and quantum of tax, proportionate share of tax that you want
my lord.
as on share of tax after revision, if any, by the individual tenants.
Great. Mike.
Deep.
Item number 3. May it please your lordship. Well, the TS 23 of 2017 is my application for grant of probate.
Who is the other side?
Other side, madam, when Mr. Shukanto Chakraborty and Arindam Paul used to appear.
What is GA9?
GA9, yes. GA9 is also my application for my reimbursement of certain expenses which I had incurred while administering the estate prior to the appointment of an
Now, let me
administrative
understand
tenant.
one thing. What is the status of the suit?
Yes.
Issues are framed?
Issues are framed. My
Evidence?
witness action is complete. Defendant are to bring their witnesses. Your lordship had been pleased to direct on 26 November that the matter will appear on 19 December under the heading witness action. My lord, on 19 December, my lord, for whatever reason, the matter did not appear in the list for witness action. And we had mentioned this matter subsequently before your lordship.
Report was there. Report was to be filed.
Yes, that is so far as the GA is concerned.
Yes.
So,
Is
so
it-
far
is it
as the
filed?
GA is concerned, my lord, your lordship has been pleased to direct the administrator pendant to file a report.
Hmm.
And so far as the suit is concerned, the main probate matter is concerned, that witness action has to proceed. So application and suit were proceeding, my lord, parallelly. Maybe because the GA
No
was...
report is there in the record.
So that is coming up on 30th January, my lord, the GA.
Oh, that is in 30th January.
On 30th January. So let that matter come up on 30th January, no difficulty. But so far as the suit is concerned, my lord, kindly fix a date
So we
for
have to
witness
fix a
action.
date for suit.
Yes.
30th January is fixed for hearing application. Full stop. However, witness action may be continued in parallel. Fixed 10th February for witness action.
Well, the 30th January, let that date be retained, my lord.
Yes, I'm not interfering it.
Very well. My lord, if your lordship pleases, my lord, I may give notice to the other side so far as 10th
Yes.
February is concerned. Grateful, my lord. Item code 5 and 6.
Would I appear on behalf of the petitioner in IAGA number 3 of 2022? My lord, this was my application under Section 8 of the Arbitration and Conciliation Act 1996.
That matter. Escrow.
Yes, my lord, the escrow. My lord, on the last.
Let me see the escrow agreement.
On the last occasion, your lordship inquired whether the affidavit filed by them
Yes,
was
is
in
it
the
there?
record.
Now you are filing today. AO affidavit in opposition.
My lord, theirs.
My lord, their affidavit.
My lord, I am supporting the petition. My lord, they had the
That application is more needed. Because you are supporting the case.
My lord, my
They are
affidavit was
opposing
there.
it. So the opposition is more needed.
My lord, mine is there.
Where is the AO?
There was a, it was reconstructed, my lord. It was already filed earlier, but it was not in the brief, my lord,
In the records of the
in the records of the court. So that my,
The department must record that if it had been filed. Any report call for করা হয়েছিল কেন দেখো তো? Possibly not.
Perhaps your lordship has not sought for a report.
Affidavit in opposition filed by the plaintiff as claimed to be filed by the plaintiff is not in the record. The department shall furnish a report as to whether any affidavit in opposition is filed by the plaintiff in GA number
GA number
GA number 3 of 22.
20.
The report shall appear in the shall be submitted to this court on the returnable date. Let the matter appear in the list On 24th January. Would you come on the date?
Yes.
Because if it had not been filed, then there is no question of reconstruction.
Yes, my lord, if it's not filed.
Item number 7.
For the respondent, my lord. They are not here. Last action direction was given to them, extend the time to file.
What is GA1?
June is it? File my opposition. They have not filed.
No, if none appears, then it will be simply dismissed.
Simple. Simple.
GA1 টাই কি বলছে?
And this is the last order. Last order. Last order.
You are for defendant?
Yes.
None appears for the petitioner. Although the learned counsel for the defendant is present. Adjourn to 26th February.
Item 8.
No, not 26th, 25th February.
Item 8.
Lordship, I am appearing for the caveator in this. Lordship, in GA number 395.
GA4 is for?
Lordship.
Lordship,
What is GA4?
Lordship, not my GA.
My lord, GA4, my lord, we had filed for. My lord, we had filed for conversion of the probate proceedings into letters of administration. That was GA3.
What is GA4?
My lord, the GA4 was.
No, sorry, this is item number 8. No GA is pending.
GA pending, my lord. They had filed a GA for
Lordship,
that got dismissed for default. Thereafter, no steps taken, my lord. And now, my lord, on the last occasion, a report was called for by your lordship from the testamentary department to see whether the citations have been appropriately issued and whether there was any paper publication to that effect. My lord, GA 395, which is GA2, my lord, that is already dismissed for default. And there is no restoration application as on date.
Which is the date, order of dismissal?
My lord, just give me a moment.
Lordship, 28th November 2024.
Yes. Well, they have not taken any steps, my lord, for having this application restored.
Lordship, we were of the view that the matter has been dismissed for default because the order says none appears. On previous occasion also none appeared. The matter is dismissed for default. Thereafter, the matter reappeared again on.
My lord, it was the GA which got dismissed for default, my lord, because the IAGA number is mentioned at the top of the order, 28th November 2024.
The whole GA is dismissed for default.
Yes, your lordship. The GA has been dismissed.
Not only GA, this is the application. This is the whole suit.
Lordship, the matter.
PLA is dismissed for default.
Well, the PLA appeared and subsequently, your lordship, the
that should not be. That should not appear. It is dismissed for default.
Lordship.
Well, the GA was supposedly
Lordship, because it is mentioned the matter is dismissed for default.
Yes, matter means whole matter.
And
not
that's why we did not take any steps, your lordship.
You have to file application for restoration.
Your lordship, this is
in terms
probably
of
the
order
GA.
dated 28 November 2024. The whole matter was dismissed for default, including GA as well as PLA. GA 2 of 2012 as well as PLA 105 of 2011. In view of successive non-appearance of the petitioner, the matter should not appear in the list any longer. However, liberty is given to file appropriate application for restoration.
Grateful, your lordship.
Your lordship, we shall take steps. Well, thereafter the order, the PLA had appeared, so we were
No, that is the last order, dismissed for default. You file application.
Yes,
I'm
Your
giving you liberty.
Yes, Your Lordship.
Item number 9.
Yes, my lord. Today has been fixed for passing order.
What is GA4?
GA4, my lord.
What is GA4?
All necessary steps I have taken as per order of this honorable court, but only one commission is required to be done, and everything has been completed.
Probate was granted.
Probate was granted, no problem, and on 24/7/24, bond was affirmed, and next stage is to be to execute the bond on 8/8/24. I gave a letter to the learned register for appointment.
GA4 of 24 is filed. Praying for engaging a court commissioner for going to the applicant's residence at এদিকে দেখুন এইটা দিয়ে দেবেন to execute the bond, full stop. The learned registrar original site shall appoint an appropriate court commissioner for the purpose. Cost of traveling shall be borne by the petitioner. You shall pay.
Yes, my lord.
Borne by the petitioner, either in cash or by arranging car.
Yes, my lord. And one thing, my lord, as
GA4 of 24 stands disposed
as
of.
the lady is suffering, is a very old one and suffering from various ailments, let the matter be completed as far as possible within a
A
short
report
period.
in this regard shall be furnished before this court on 30th January.
Much obliged, my lord.
Item number 10.
My lord, in this matter, my lord, on 12th December 2024, your lordship passed the order for substitution. And my lord, one point was taken that at the time when I prayed for substitution, the name of the death certificate was not there. And your lordship directed that a commissioner of the Kolkata Municipal Corporation will furnish that. Lord, I do not know, my lord, I have written the letter also. So, my lord, I need not produce the death certificate. I have brought the death certificate also.
Learned counsel appearing for the Kolkata Municipal Corporation produce the certified copy of death certificate of deceased Nader Chand Barik, who breathed his last on 27/11/2023 at 150 by A Acharya Prafullo Chandra Road, Kolkata 6. Do you need a copy of this report?
I do not possibly. No, report in objection. No, my lord.
No, this is death certificate.
No, my lord, I do have. On the last occasion, I did not produce, could not, my lord.
They say death certificate is produced bearing certificate with a certification of Deputy Chief Municipal Health Officer, KMC, dated 10/1/25. Let the same be kept in record. Now tell me what you.
One thing, my lord. So far, the order dated 12 December 2024 is concerned. My lord, in 5th line and 10th line, the date mentioned 23rd November 2023, my lord, should be, my lord, 27th November. 5th line and 10th line. both parties submitted that 23rd November died. In fact, it should be 27th November.
Next para লিখুন,
Yes.
place of death and date of death as noted in the order dated 12 December 2024 be corrected to the extent that Nader Chand Barik breathed his last at ওই APC রোডে অ্যাড্রেসটা দিলাম না, ওইটা দিয়ে দেবেন on 27/11/2023.
So, my lord, substitution be effected?
হ্যাঁ বলুন।
লর্ডশিপ নদের চাঁদ বাড়ি থাকতেন 2/1 রাজা রাষ্ট্রীয় স্ট্রিট।
আমি এখানে যা রিপোর্টে যা দেখছি তাই থাকবে, আমি রিপোর্টে বাইরে যেতে পারবো না, ডেথ সার্টিফিকেটে যা আছে তাই থাকবে। আপনি বলেছেন, আমি সেটা নোট করেছি, কিন্তু ডেথ সার্টিফিকেটে সেই ডেট নেই, সেই অ্যাড্রেস নেই।
আমি অনারেবল কোর্টের আদেশ আছে, আমি সেই অর্ডারটা এনে লর্ডশিপের কাছে নেক্সট তারিখে প্লেস করব যে উনি 2/1 এতে থাকতেন।
তাহলে সেইটা নিয়ে মারামারি করে লাভটা কি হবে? আপনার মামলা এগোবে?
কিন্তু লর্ডশিপ সত্যিটাই সব থেকে
আমি রেকর্ড দিয়ে যাব, ক্যালকাটা মিউনিসিপ্যাল কর্পোরেশনের যা রেকর্ড তাই দিয়ে যাব। আপনি যদি সেইটা প্রমাণ করাটা বেশি দরকার হয় আপনি করুন, মামলা দেরি হবে, আর কিছু হবে না। আপনি সত্যি বলতে চাইছেন, যেটা সত্যি হবে হবে, প্রমাণ হোক সেটা, মামলাটা দরকার নেই হওয়া। কোনটা চাইছেন?
লর্ডশিপ দয়া করে যেটা আদেশ করবেন।
না, আমি কোনো আদেশ করবো না, আপনি যেটা চাইবেন, আমি আপনাকে বাধা দিতে পারি না।
লর্ডশিপ তাহলে হিয়ারিং এ আমাকে একটা কপি দেওয়ার আদেশ যদি
Copy of the death certificate may be handed over to the learned counsels as well as to the party in appearing in person.
Well, I have a copy. Can I hand?
No, this one.
My lord, my lord, my lord.
Now the suit issues are framed.
Substitution be effected, my lord.
Which substitution?
This the caveator's sons and heirs.
লর্ডশিপ আমি একটা হিয়ারিং এর জন্য তারিখ প্রার্থনা করছি।
Oh, God.
Your name?
আমার নাম জয়াবতী বারিক ইন পার্সন।
Jayabhuti Barik appearing in person. Praise for accommodation. আপনাকে তো নিতাই বারিক, নিতাই চন্দ্র বারিক ছিলেন, তার জায়গায় আপনার নামটা আনতে হবে।
No. The heirs has already been effected, to be effected, my lord, as per GA number 7. That is the application. And your lordship has passed the order.
নিতাই চন্দ্র বারিক.
Yes, on the death of Nitai Chandra Barik, his heirs would
That means she is one of the heirs.
No, she is not. She is already the party because she has already filed.
Let me adjourn when she is praying.
But only one more submission. Well, GA number 8 of 2024, which she herself has filed for substitution, may be directed to be
GA number
8 of 2024, which is appearing today. Same prayer of substitution. Can you look at my lord prayer portion, my lord? There, my lord, even Nader Chand Barik's heirs have been included together, current petition.
Let it be adjourned.
Well, only one thing, my lord, may I pray? My lord, in person she is appearing, I am handing over. The other copy I will have the lawyer. My lord, kindly record it because I cannot.
Copy of a death certificate is handed over by the learned counsel. Copies of death certificates are handed over by the learned counsel for KMC
In court.
in this court today to the learned Mr. Chakraborty.
No, he is not given to me.
No,
He
I am giving in person.
Jayabhuti Barik.
Other I will.
Handed over to Mrs. Jayabhuti Barik, appearing in person. On prayer of Mrs. Jayabhuti Barik, hearing of GA 7 of 20 and GA 1 of 2012, GA 8 of 2024 is adjourned to 28 January.
Grateful.
28 জানুয়ারি আসবেন।
Hi, Lordship.
Item number 12.
Application, Your Lordship kindly remembers on the last occasion of place, my lord, an application for intervention in an application for grant of probate, which has been subsequently turned contentious.
GA1 of 2024.
My lord,
This is an application for intervention.
this is GA5 of 2020.
GA1, what is GA1?
Well, GA1 is my application for administrator pending lighting in the another PLA. My lord. Another PLA. This, my lord, kindly see the another PLA is there, my lord. It is not the PLA number
What
one.
is the intervention application? Let me see it.
There is a GA5 they filed, my lord, the alleged wife.
The petitioner before Your Lordship is the wife of the testator. In support of that document.
Any affidavit?
Yes,
Yes,
pleading
my
has been
affidavit
completed.
is-
Last occasion, my learned friend argued this matter. The matter is part heard, my lord.
Claims to be the wife.
Yes, she's the wife. Your Lordship kindly sees the affidavit in opposition because she had a knowledge. Now she is no more in the world. The executrix before this this application, executrix, namely, she was subsequently substituted.
No, this application is filed. अरे 2 तारीख affidavit reply দিয়েছো কেন? Application কোথায়? তাহলে এখানে affidavit reply কেন?
Jhunu Banerjee was the executrix who subsequently left for heavenly abode, and there was further substitution.
So testator was Vishwadev Banerjee.
Vishwadev Banerjee.
Now the application was filed by Reena Banerjee.
No, this application was filed by Chanda Chatterjee, Banerjee, who is the
Chanda Banerjee.
Chanda Banerjee. Who is the
Claiming
wife.
to be wife.
She is the wife. My lord.
Now
In
this
support-
Chanda Chatterjee Banerjee has also expired.
No. This is my application for intervention. Chanda Chatterjee intends to intervene in this application.
Claiming to be the wife.
She is the wife. But in support, my lord, we have filed our marriage certificate and also other correspondence.
Yes, what do you have to say?
My lord, kindly take the marriage certificate.
Just 1 minute. And testator was working in the government of West Bengal in the health department. After his death, he died in harness. After his death, the petitioner before Your Lordship is getting pensionary benefits and some portion of the gratuity and all those he is also
Right.
getting. And
Yes, what is your objection?
Yes, my lord, kindly. My lord, the will was executed by the testator on 18 August 2023. 2013, my lord. The testator died on 15 November 2013. Probate application was made on 26th.
Your
June
allegation is
2015.
false certificate of marriage and
Yes,
she
I'm
is no
coming
longer
there.
wife.
I'm coming there, my lord. There's a two issue. This is not a suit, my lord, per se. It's a probate application. My lord, Order 7 Rule 11, Section 9 CPC, my lord, applicable over here, my lord. This is a suit. Simply, it is not a suit. It is an application, my lord. So nobody come to appear in Order 1 Rule 10 to application. If she has a caveatable interest, she has to file the affidavit in support of caveat after seeing the citation, my lord. The citation was issued on 2015. My lord, after issuing the citation, the marriage sisters of the deceased was filed the affidavit in support of caveat in the month in 23rd November 2015. Well, thereafter matter has been transferred in the contentious proceedings and the testamentary suit was given. And after filing the testamentary suit number, another affidavit in support of the caveat was filed on 2nd August 2017. And the 2nd August 2017, the defendant was saying there was the testator was married. And now, my lord, in June 2024, the lady is claiming herself as the alleged wife of the testator. My lord, kindly come look at their application. What is there's a 2, my lord, marriage certificate annexed over here, my lord.
You refer your points
My lord,
of
I'm
objection.
coming. I'm point of objection coming. First, see the, my lord, kindly come at
Where have you mentioned this issue? Which paragraph?
Well,
False, you have stated false marriage certificate, that is in para C, sub para C.
Kindly see the, kindly take page 13 of their application. Kindly see the marriage certificate first, my lord. There's a two marriage certificate and enclosed over here, my lord. Page 13, the certificate, my lord. It is written, my lord, left hand side K 56/5570. My lord, left hand side, kindly mark this, my lord. Page 13 below, this is a marriage certificate.
Which one?
Page 13 below, left hand side.
Yes, which date you are saying?
This is, my lord, it is true copy. It is written 2nd May.
Which to be marked? Which is to be marked?
My lord, kindly take page 13 of
Yes.
their application.
Yes.
This is one showing there the purported marriage certificate.
Yes.
Kindly take the West Bengal form number 1635 written over there, my lord, left hand side top. Just below K 56/5570. My lord, then see, my lord, I such and such hereby certified that on so and so such and such Biswadev Bandyopadhyay, son of so and such, no address was there, my lord, where is he residing. And Chanda Chattopadhyay, daughter of such and such, what is the address is not written over there. Marriage has been solemnized. There is no section because it is, my lord, is a special marriage act. For the special marriage act, section 5 notice to be there. Thereafter, section 11, the declaration is there. My lord, nothing is there. And my lord, this is the true copy.
We are not deciding whether the marriage
Prima
was
facie
actually
case is-
valid or not.
My lord, prima facie case is this, my lord, he has to satisfy his a wife. First, he has to
The
show.
marriage certificate is there.
No, it is not certificate, a true copy. Kindly see, kindly comes another second page, 14. Kindly page 14. It's a true copy. A highly suspicious document, my lord.
Since
Kindly come
the
page,
certificate of marriage is challenged
page 14, my lord, kindly see once.
in GA5 of 2024,
Let them produce the original one.
it is necessary that the original certificate of marriage should be produced. Where is the original?
On next date, I can produce. My lord, the second is the certified copy because
The original
the true
marriage
copy.
certificate should be produced by the petitioner in the form of a supplementary affidavit on the next date.
and your lordship kindly sees annexure C also.
Next,
page
the
16.
matter will appear in the list on 11 February.
My lord, kindly check the order, my lord. Order is written GA1. My lord, instead of GA1 will be there. GA5 also mentioned, my lord, order, my lord. Kindly see the last
This
order
is
is not-
GA5.
My lordship's order is not mentioned the last date.
We are hearing GA5.
GA5, my lord.
ওটা কি
GA5
বললাম সেন্টেন্সটা কি বললাম?
Certificate of marriage is challenged in GA number 5 of 24.
হ্যাঁ ঠিক আছে ঠিক আছে
I'm grateful.
Item 13.
My lord, I appear for the petitioner. My lordship would recall this is my application for revocation of grant of probate.
Who is the other side? Mr. Mukherjee, you are submitting.
My lord, your lordship, if your lordship recalls, my lord, this matter, there was a dispute as to regarding the signature. So, my lord, it was your lordship's view, my lord, that a handwriting expert should be appointed. My lord, I had submitted that the original signature has to be there with which it has to be compared. So, the person concerned.
Is there
whose
any
signature-
application to this effect?
No, my lord, there is no application.
Then
It was your
why
lordship's,
should court will go into that?
My lord, your lordship, your lordship
fell
wanted.
from
my
Court
lord,
will not fish out any evidence.
No.
The party is to be proved. Party is to make application.
Yes, ma'am. Because it fell
Yes.
from your lordship at that point.
No,
but,
I should not. Yes, the only issue is that at the time of filing the caveat or at the final of no objection, the signature was forged and she was not there.
That
She
is
was
what
in
she is
Australia.
claiming. That
That
is
is
what
the
has been
point.
claimed.
And what is your reply?
My reply is, my lord, that the signature is correct. It is not, it is her signature only. She had consented to it. The facts surrounding it, my lord, I will be able to establish that also by evidence. Establish that.
Second issue is limitation.
No, limitation is not
Is
an
not
issue.
an issue here, my lord. Limitation is not an issue here. My lord, may I take your lordship through the documents, my lord?
I've seen this. Passports, signatures, and all these things.
My lord, passport signature.
If
your
someone
lordship will-
challenge the signature, someone say, though this is not the signature,
my
it is for him to prove it. Why the court will go into that?
No, my lord, I can show that, my lord, the signature appearing in the consent affidavit is not of the petitioner. because Lordship can see,
Then only recourse you have to take is to file an application for examination by handwriting expert. Court will not presume that. There is a provision in Evidence Act,
Yes.
but that is these things are to be resorted in rare situations.
My lord, ideally, even I would agree, my lord, that in fact, I would say, my lord, more than the handwriting expert, the lady concerned who is saying it is not her signature, let her be brought on box. My lord, there is law, my lord, and in fact, I have supported
lord,
by
for the-
judgments. Let me complete at least.
When
It is
someone is
supported by-
making certain submissions,
my lord.
he must give it to supporting evidence.
Supporting evidence and here,
As
my lord,
materials. If
here,
it is not
there
done, then
there is also, my lord, this established practice of trial by evidence, which is also accepted in revocation of probate matters, my lord. If this lady is brought on record, she's brought in the
that
box.
is not your cup
she
of
will-
tea.
I'm
That is
not
not
my
your
cup,
headache.
but all I'm saying is everything will
Anything
become
else
clear.
to submit?
Well, I'm ready with the matter to argue.
Yes.
If your lordship wants me to start. If your lordship pleases, my lord, that application should be filed for handwriting expert, that's a different matter. But otherwise, I'm ready to
I will
argue.
not allow any liberty. I am not given any liberty. It is for them
For them.
to prove their case.
Yes, my lord. So have you finished your argument? Yes.
Yes, because I have shown your Lordship, my lord, 2 to 3 documents. My
You
lord,
have shown me. I have noted this.
My lord will take the application, which my learned friend has filed, and also the probate petition, my lord, which was originally filed. My lord, your lordship has the probate petition. Probate petition.
Now, one thing we must explain.
Yes, my lord.
Yes.
Two things cannot be all at the same time. One is forgery, another is fraud. One demolishes the other. Fraud means someone made tricks on you, inducing you to put your signature.
Yes.
That is fraud. And forgery means without your knowledge, beyond your knowledge, someone put signature. So these are contradictory. Anyway.
I will. My lord will come, my lord, their application for revocation, page 10, the genealogical table which is there. Your lordship has to understand who has filed, what is the application about, and who are the family members involved. So lordship takes page 10, my lord, of their application. That is GA. GA1, my lord. Page 10 is the genealogical table.
Yes.
Shamsundar Lohia, my lord, that's the person who is deceased and whose will is subject matter. My lord, as you see, my lord, your lordship, he had his first wife, Geeta Devi Lohia, and second wife, Sita Devi Lohia. First, from the first wife, he had 3 children, Basant Kumar Lohia, Kusum Poddar, and Madhu Barlia. From the second wife, there is Sangeeta Savadia. Sangeeta Savadia is the one who has filed this application for revocation.
Mr. Mukherjee, your whole argument is confined to a single point.
Yes, my lord.
That probate of the will was granted, forging her signature or practicing fraud upon her.
I will show your lordship. That is why, my lord, just to show what were the facts, surrounding facts. Now, my lord, if your lordship sees, my lord, the genealogical table so far as coming from Geeta Devi Lohia, there is a son and 2 daughters. My lord, all the children, everybody, your lordship sees Aruna Lohia, Nupur Sharma, Pratik Lohia, Shiv Shankar Poddar from that list, Saurabh Poddar, Sameer Poddar, Sandeep Poddar. They have all given their consent affidavits. Similarly, Sangeeta Savadia, she had also given her consent affidavit. It is on the basis of 8 consent affidavits that the probate had been granted. 8 consent affidavits. It is now the contention of my learned friend that Sangeeta Savadia, her consent affidavit is forged. Her signature appearing is forged. Your lordship will take my affidavit in opposition now, my lord. My lord, few dates which are important, if your lordship just notes down.
GA1 is revocation.
GA1 is revocation. Few dates which are important. First, 29th March 2017 is the registered will. The will is a registered will. Then 11th October 2017 is the death of Shamsundar Lohia. Your lordship will now note down 1st April 2018.
Yes, which paragraph you are referring to, AO?
AO. My lord, I'm if your lordship comes, my lord, straight to page declaration to kothay ache? My lord, page 26. 26.
Hmm.
My lord, this is a document. Your lordship turns over, your lordship will find that there is a next document is dated 2nd April 2018. Next document, next page.
Hmm.
And this document, well, is a document of 1st April 2018. Let me read it out.
Hmm.
We, the persons named herein below, being the legal heirs of Shamsundar Lohia, the deceased above named, do hereby declare that we have no objection whatsoever to the grant of probate in the goods of the said deceased in favor of the petitioner above named by this honorable court, and we hereby accord our consent for the same. My lord, then your lordship will see the persons who are named: Sangeeta Savadia, Madhu Barlia, Saurabh Poddar, Samir Poddar, and Sandeep Poddar. And next page, if your lordship turns over, this is Nupur Sharma. She's the person who has filed the application, the petitioner. Be it known to all that as per the last will and testamentary of Shamsundar Lohia, who expired on 11th October 2017, registered with Additional District Sub-Registrar Office of ADSR, Shialda, South Chobbish Parganas, West Bengal, 29th March 2017. I, Nupur Sharma Ni Lohia, daughter of late Basant Kumar Lohia, predeceased son of late Shamsundar Lohia, have been appointed executrix to the estate of Shamsundar Lohia. As was informed to all concerned on 1st April 2018, when the said will was read out by me at Alipore in presence of several family members, including heirs in intestacy, that late Shamsundar Lohia has bequeathed his entire estate to Pratik Lohia, son of Basant Kumar Lohia. I shall be taking steps to obtain probate of the aforesaid will and testament of late Shamsundar Lohia from the High Court at Calcutta. In this regard, I shall require all the heirs in intestacy to provide their consent and no objection. A copy of the declaration by the legal heirs in intestacy is enclosed herewith for signing by the respective heirs in intestacy, which may be used in the petition that I would be filing for grant of probate. So, my lord, on 1st of April, the will was read out and a declaration was given by 5 of the legal heirs. One of them includes Sangeeta Savadia. Her signature is there, and that's the same applicant who has come before your lordship. On 2nd of April, Nupur Sharma, who's the who's the executrix here, she filed this application. She circulated the no objection certificate or the consent affidavit. That consent affidavit was with this Sangeeta Savadia as also the other legal heirs. She signed it and returned it to Nupur Sharma. Nupur Sharma thereafter filed the application for probate. So the dates which I was telling your lordship, if your lordship now just considers, 29th March 2017 is the registered will. 11th October 2017, the person died, deceased. 1st April 2018, will read out and that declaration given with her signature. 2nd April is the circulation done. Now 30th November 2018 is the probate petition which was filed along with the affidavits which are there. The affidavit concerned, my lord, if your lordship takes, my lord, now the probate application, or my lord, your lordship can also take this the application for revocation. There also, my lord, this affidavit is there of Sangeeta Savadia. My lord, page 18. Page 18.
Yes, that signature is there.
That's same signature is there. Now, my lord, if your lordship just takes, my lord, it is my learned friend's contention. There are two contentions. Well, if your lordship sees the affidavit is of 11th December 2018, my learned friend's contention number 1 is that Sangeeta Savadia was not present in India on 11th December 2018. And number 2, the signature is not that of Sangeeta Savadia. These are the two contentions of my learned friend. I accede to the first one. She was actually not in Calcutta on 11th December 2018. My lord, as your lordship knows, my lord, that she was in Australia. She had given the affidavit. It was Notarized.
Date was subsequently put.
Date was subsequently put. But the signature is that of hers. That is not, that we are, my lord, absolutely not disputing. We are, my lord, it is our statement, my lord, if that lady, there are others surrounding circumstances, which, my lord, I have made in my affidavit, which will show why this application has been filed. That is why I was showing the genealogical table. Now, my lord, if you're, so along with this affidavit, there were 7 other consent affidavits which were filed. If your lordship takes, my lord, the probate now, the probate petition. If your lordship takes the probate petition.
Where have you stated in your affidavit? Because I have to go through your affidavit.
My
Which paragraph should I go into?
Yes,
Go
my
through.
lord. If your lordship takes, my lord,
Subpara 10.
My opposition, your lordship starts.
Subpara Roman 10.
Subpara Roman 9 onwards, page 3, Roman 9 onwards. My lord, if I read it out. The applicant has filed the instant application on suppression of facts and making false statements, knowing those to be false. The instant application is a gross abuse of process. The applicant at all material times had due notice and knowledge of the last will and testament of 29th March 2017. The applicant had notice and knowledge of the fact that the father, being the deceased, had validly executed the last will and the fact that the same was duly registered. The applicant had also notice and knowledge that the deponent was the executrix to the last will. After demise of the deceased, in the presence of several family members and heirs in the intestacy, including the applicant, the last will was duly read out on 1st April 2018. Upon being read out, the last will was present all parties, including the applicant, were informed that the deponent was the executrix thereto and that the beneficiary of the estate of the deceased was Pratik Lohia. Although the applicant was aware of the last will, this was necessary for no objection from all heirs in intestacy so as to file the application for grant of probate of the last will. Copies of affidavits affirmed by other daughters of the deceased, namely Madhu Burlia and sons of and other sons, and one of the sons of the predeceased daughter of the deceased, namely Saurabh Poddar, are annexed here to and marked. From such affidavit, it would be evident as follows. Number 1, on 1st April 2018, the will was read out at 7E Raja Santosh Road, Alipur. Various persons including Sangeeta Savadia, Shiv Shankar Poddar, Madhu Burlia, Saurabh Poddar, Ashutosh Lohia, Vishnu Lohia, Bhagwati Lohia were present. After the will was read out, as aforesaid, all heirs in intestacy, including the applicant, had consented to the executrix, being the deponent herein, to take steps for obtaining probate of the last will. Accordingly, a declaration to such effect was drawn up and forwarded, and a no objection thereto was duly signed by the applicant on 2nd April 2018. Documents evidencing such was annexed. Thus, it is evident that the applicant had full notice and knowledge of the registered will at least on 1st April 2018, if not before. The applicant has also taken further steps in terms of and furtherance of the last will. An affidavit of consent was duly signed and executed by the applicant on 4th April 2018 to enable the executrix, being the deponent herein, to take steps for grant of probate by compliance of all necessary formalities. The said affidavit of consent was signed on 4th April 2018 prior to the applicant leaving the country. The applicant signed the declaration and no objection on 2nd April 2018 and thereafter signed the affidavit of consent on 4th April 2018 to enable the deponent to obtain probate of the last will of the executor so and so. Due to certain legal modalities, the deponent was advised by her advocate on record that the affidavit of consent signed on so and so could
Yes,
not
I have
be.
gone through it.
Yes. So there is no doubt about that. Only issue, what has happened, my lord, is, my lord, if I take your lordship back to the
Come on the next date,
genealogical
Mr.
table,
Mukherjee.
my lord.
Come on the next date.
Another date, my lord.
I have to finish the list. Hard in part adjourned to at a date below. Can you come tomorrow? No, tomorrow. Not.
Tomorrow, yes, my lord. Only, my lord, next week I have some inconvenience. Only next week. To this week, no problem. Any day.
Any day.
Any day. Next week I have some inconvenience, my lord, personal inconvenience. But my lord, can it be day after? My learned junior has some inconvenience tomorrow. Day after?
No, not tomorrow.
Oh.
Purshudin.
Purshudin.
That is 16 January.
16 January. Great. My lord, I will have to take your lordship through some documents here. That is only thing. That is why it's taking a little while. Man.
Finish it next day.
Item 14.
Whether I appear for the petitioner.
For the defendant, There is a happy development. The matter has been amicably settled. So I am filing an affidavit to that effect. The defendant will no more object grant of probate.
My lord, I don't stand in the way. Only one thing, my lord, this is a testamentary suit, my lord. The grant of the probate of
Did
the
not file
testator.
this one. If you do not appear, probate automatically will proceed with.
Yes, my lord, I have to discharge
My
my
lord, I
burden to
will-
prove the
that
will.
may be recorded,
Yes, I
kindly,
have
my
to do
lord.
that.
That I will not
That
appear.
is taken on record.
Issues were framed.
My lord, issues were framed. There was a caveat, my lord. They filed an affidavit in support of caveat. Initially, my lord, may I just indicate, here they had filed a no objection, my lord. Initially, there was a consent affidavit filed by my learned friend's client, my lord. Thereafter, they reneged on that and they filed an application for filing of a caveat. They filed the caveat.
Learned
and
counsel for is for the only
only
caveat.
one defendant, but only one caveat.
one
my lord.
Caveator
That's the son of the testator.
filed an affidavit today stating therein that he has no objection in grant of probate and he will not stand on the way. Full stop. In view of that, caveat is discharged. Let this suit appear in the list. No, ওটা লেখা দাও, caveat discharge লেখার দরকার নেই. In view of that, let the suit be proceeded
Right.
with fix, proceeded with full stop fix. একটা ডেট বলো।
My lord,
এখন কি? 30th January.
my lord, this is coming up for final arguments. My lord, we already
Witness action
there's
is
a
there.
yes, it's already done.
Will is
There's a commissioner
exhibited.
upon. Will is already exhibited. Everything done, my lord. It's only for me to advance our arguments. That's it, my lord. There was a commissioner appointed. He's already filed his report pursuant to my lord's directions, my lord, wherein my lord the evidence of the attesting
Will is
witnesses.
marked.
Will is marked. Will signatures of
Have you
testator,
adduced
everything.
evidence?
He has cross-examined my witnesses, my lord.
I had
He has
crossed- I
cross-examined.
কি বললাম আরেকবার ফ্রেশ করে লেখো। Learned counsel appearing for the defendant files an affidavit today stating that he will not stand in the way in grant of probate. Full stop. The suit is a contested one. Full stop. Since the petitioner will not contest the matter any longer, but has cross-examined the witness of the petitioner, of the applicant, examination of witness on behalf of defendant stands closed. Fix. January for argument.
My lord, we'll come with our notes also on that day, my lord. We'll
You may
file it
come,
with-
may not come.
My lord.
Only I have to check whether the probate is
Yes, my lord,
will
the
is properly marked or
genuine.
not.
My lord. Obliged.
Item 15.
15, I am adjourning it. I will not be able to frame issues today.
No, my lord, this is not for framing of issues. Kindly, I'm appealing for the defendant. Kindly seize the last order of 29th of November 24, where liberty was given to me to file an application challenging the jurisdiction of the court. Now, my lord, what I said, my lord, was that this involves a commercial dispute, so needs to be transferred. So I am not challenging. I don't want the suit to be dismissed, at least not on this ground. But the suit needs to be transferred because this. Now, if my lord wants, I can file a formal application for transfer. But this is in respect of a transaction between bank, my lord. Cash credit facility, my lord. Kindly seize the reliefs, which are at pages 28.
When the suit was filed?
Well, the suit was filed in 2017. I'm being
2017.
led by Mr. Banerjee, who's online, my lord. Mr. Siddhartha Banerjee is online.
Mr. Siddhartha Banerjee, what do you have to say?
Inaudible.
Where are you sitting?
Mr. Banerjee, we can't hear you.
Mr. Banerjee is inaudible.
Mr. Banerjee is dumb today. Now covering this camera.
No, Mr. Banerjee, you're not.
Not today, not today. Not today. Next matter.
16. Item 16.
Today is fixed, my lord, for framing of issues, my lord.
That was on video conference hearing.
Yes, my lord.
That order was passed, I think.
Yes, my lord.
The
Your
order
lordship,
was passed, the commissioner has already set down the procedure and my lord, appointment has been made and
Now, what order is to be passed?
issues are required to be framed.
whether he is entitled to partition or partitions.
Partnership suit.
Yes.
Partition suit.
Partition suit. Lord, I am filing my suggested issues.
Come tomorrow.
I have served the copy.
Mr. Datto, come tomorrow.
Lord, let an order be passed, my lord, regarding filing.
আচ্ছা ঠিক আছে দিয়ে দাও আমি দেখে অর্ডার করে দেবো চেম্বারে দিয়ে দিও I will try to frame the issues today or tomorrow.
Yes, my lord.
I will try to frame issues today, if not possible tomorrow.
Partition suit without what issues will be framed, whether the parties are entitled to their share.
No, the title may be questioned.
They have questioned the title. That's the reason, my lord, why I have not come and asked for preliminary degree. Otherwise, I would have. Lord. Anyway, my lord, I don't stand in the way.
চেম্বারে পাঠিয়ে দাও
Whatever way your lordship places it, but not tomorrow because tomorrow I am in some.
No, you have to do nothing. You have filed suggested issues. If I am able to frame the issues today itself, it will be uploaded. Or tomorrow I will frame it.
Very well. Is my lord keeping the matter
Not
returnable?
today. Only
Very-
making not. I'm not making not today. এটা আমাকে পাঠিয়ে দাও আমি দেখবো যদি অর্ডার হয় করে দেবো
Issues are framed, my lord, then
We can
start
proceed with the
Ah.
commission. That is why.
17.
Very well, my lord. Extremely grateful.
Any expected date for witness action?
My lord, that, my lord, the commission will have to fix because, my lord, everything is happened. The remote point, remote coordinator has been fixed. The procedure has been agreed upon. Only
Then after framing of issues, I will fix it for further order.
Yes, yes.
That would be better.
whatever your lordship.
This was only, my lord, I was asking for.
That would be better.
Your lordship may kindly provides a date, my lord, either this week or next week.
No, not next week. February. I will check a date. I will fix it.
Very well, my lord. Extremely
Mr. Ali is very hopeful,
No, no.
very optimistic.
Regarding
Short date.
good to be optimistic, but he knows there is no dates available. This puts me very happy.
Other matters are there.
Yes.
Extremely good.
31st is okay? 31st January?
Yes.
Item 17.
Lordship, I am for the plaintiff, man. Last occasion, I took direction for filing appropriate application for addition of party, my lord. While making the application, I find that the defendant has gone into liquidation during the pendency of the suit. My lord, thereafter, the company has revived. My lord, since the writ of summons have already been served upon the defendant, my lord, I'll issue a fresh notice informing them that the matter is returnable on such and such day.
Summons were issued.
Yes, yes. And after the issuance of the summons, my lord, the company went into liquidation. A new company has taken over, my lord. It is
Whether
now
this is the commercial dispute or not,
it's a commercial dispute.
then it should be transferred to commercial division.
Lordship will kindly transfer it. My lord, this is regarding, my lord, payment of central sales tax, my lord. They did not
Payment of?
Central sales tax, my lord. C form, they were
In
supposed
course of usual trade and commerce, the suit partakes the nature of a commercial dispute. Hence, it is transferred to commercial division. Department shall take necessary steps in this regard. Let the suit appear in the list on 21st February. Copy of this order may be sent by the plaintiff to the defendant.
18. I'm for the plaintiff. My lord's order of 3rd of December 2024, my lord. If my lord has recorded that substituted service in respect of defendant number 5 has
You are
been
for?
done. Defendant number 5.
Defendant number 1 to 4 and 6.
1 to 4 and 6 is already been declared as undefended suit because they did not enter appearance.
Some defendant is contesting.
Defendant number 5 has not filed written statement even after
My lord,
No, it is a contested or undefended.
my lord was kind enough to grant us leave on the last day to file Wakalatnam, and after the changeover, we are the new council on the board, and we have recently filed an application for leave to file witness statement for defendant number 1 to 4.
Or?
Witness statement. for 1 to 4 and 6.
So,
It,
my lord,
wa-
different
it
number
was
five
all
is
part of
covered
the, it was all lapses on the part of the earlier advocates. We have mentioned that in our
It is
petition.
very easy thing to blame the advocates
They live,
to cover up your latches.
my lord, they live in Rajasthan.
Whatever that might be.
All the defendants, they live in Rajasthan. None of them are here.
CPC time frame is not specific.
And not only that, they are very elderly, my lord. My lord will see.
Come with an application, I will
They
see.
had, my lord,
We have
ended
filed an
appearance.
application
But
today,
still nothing has
permission to serve them right in front of you, my lord.
happened. They can service otherwise also. They don't need permission to serve us.
Let that application come.
It has been filed today only, and
They should,
could we just...
they should serve a copy. It's
At
not
least
appearing
this
to-
application is not in the list today.
No, it's
So
not.
it will come, let it be listed.
In fact, my lord, defendant number 5, since nobody is appearing for defendant number 5, that can be declared as undefended because
What is the use in it?
Defendant number 5 has recently been served, my lord, by
No,
substitution.
what you
served.
want to propose?
Yes,
What
I
you
am.
want to propose?
I am also appearing for
Compartmentalize
defendant
the
number
whole
5.
evidence.
now my learned friend says he's also appearing for defendant
Yes,
number 5.
I'm appearing for
Whatever
defendant
that
1 to
might be.
6.
Do you like to compartmentalize giving evidence?
No, my lord, if today that
Then-
application is filed.
Not only that, man, they do not have clause 12 leave, and yet they have
Please.
proceeded, my lord, this far.
Slow down your voice.
I will, my lord. My apologies, my lord. They do not have clause for 12
It is
leave yet.
submitted by the learned counsel for defendant number
1 to 6.
1 to 6. That application has been filed.
No, this application is 1 to 4 and 6, and 5 would be filed, I think, tomorrow, is it?
He's appearing
Yes.
for 5 or not, that's
Not, I'm not appearing for 5 today.
he should not be saying he's appearing for 5.
As an applicant,
Why is he?
I'm appearing
Be
as-
very clear on
Yes.
one point.
I
Who has filed the application?
for 1 to 4 and 6. And I'm also appearing for
Learned
defendant number
counsel
5.
who has appeared on behalf of defendant number 1 to 6 submitted. That application has been filed on behalf of defendant number 1 to 4 and 6, seeking leave to file written statement. Have you served copies?
No.
I can serve them now, man.
Copies to be served. Copies be served to the plaintiff. Let the applications appear in the list on 25th February.
Grateful.
My lord.
Served in the course of affidavit in opposition shall be filed within 2 weeks. Affidavit in reply, if any, shall be filed within 1 week thereafter.
Grateful, my lord.
The applications will appear in the list on कभी बोल रहा हूँ?
25th February, my lord. Grateful, my lord. Deep. Commercial Division, item 11.
Before your lordship takes up item 11, item number 16 was framing of issues, Millard. Both Mr. Dutt was there on behalf of the plaintiff. Millard, I should have pointed out that your lordship had disposed an order 7 rule 11 filed by the defendant, where certain issues your lordship had reserved for trial. This is the order. Your lordship, Millard, has kept the matter for framing of issues. At the time of framing of issues, your lordship may consider this order. This was, Millard, our order 7 rule 11 application was rejected. That is the only reason.
Question of title and interest, the point has been already been given in the registered issues by plaintiff. So that
Question of right title interest.
Yes, I wanted your lordship to kindly consider your lordship's own order.
এটাকে দিয়ে দেবে তো ওইখানে চেম্বারে পাঠিয়ে দেবে।
I'm deep love. My lord, kind indulgence, my lord. This is with regard to item 21 I mentioned in the.
Yes, adjournment was sought for.
Yes, my lord. My lord, if this matter can be kept at 3:45, Mr. Banerjee, who is.
Oh, he is seeking for time. I have other matters. I cannot wait for one matter.
My lord, then some other subsequent date or tomorrow at 12 o'clock.
My witness in the box, I'm the defendant. My witness Miller travels from Delhi.
From
Delhi. He had traveled for today, but my senior friend indicated that the examining counsel has a difficulty for the period 2 o'clock to 3 o'clock.
When he will be able to come?
He is present today. He is also present tomorrow. I was humbly beseeching my lord that I had spoken to Mr. Banerjee. He indicated that possibly he'll be able to conclude in the event he is given an opportunity today at 3:45. I was humbly beseeching my lord to kindly keep it at 3:45. Because I am given to understand that Mr. Banerjee.
That matter.
Yes, my lord.
Yes, I understand. I will take up. If time permits, then I can do. Let me see. Let me hear the arguments.
In that event, my lord, may I request one other thing, my lord? If my lord list so permits, if tomorrow at 12:30 the matter could be fixed, possibly Mr. Banerjee would conclude. I know my lord has specifically designed my lord's list in a way that the hearing matters and witness action takes place only in the second half. But I'm given to understand Mr. Banerjee has
adjourned to 15 January to be fixed at 12:30 p.m.
Extremely obliged.
Regarding item 20, it's a witness action. It's my fault. There's a medical emergency in my house. For cross-examination purpose, I could not get.
Who is your other side?
Mr. My wife has some problem. Kindly adjust it and keeps it any date convenient.
My witness will be here. My witness.
I indeed.
Next week. Next week.
Not on 20th. Not on any day other than 20th or
any date, Lordship.
Adjourned to 29 January.
Great. Much of it.
This is item number
20. I'm grateful.
Your Lordship, I'm mentioning a company petition being CP number 211 of 2015. Your Lordship,
item number 10, Commercial Division.
Item 11.
Your Lordship,
Item number 11, Commercial Division.
Today, Mr. Mitra was arguing. I was here for the plaintiff. Mr. Mitra was making his submissions.
But on the last day, I've given my lord the brief background of the case. This is that matter where the defendant.
Yes, I remember.
Yes, the counterclaim.
He came from Kochi.
Kochi. The main interpretation remains on the letter of appointment and how the parties have acted upon in terms of the appointment. Now, Lordship I will just hurriedly take Lordship to the plain and written statement the case. Because last day I was just made an oral submission, I didn't take the court through the plain and written statement. So for the plain case which runs, that this plaintiff company took over, the new management of the plaintiff company took over pursuant an order of the National Company Law Tribunal. And then, but earlier, the defendant was the main promoter. That's the paragraph 2. One of the promoters of the plaintiff company was the defendant. So it was initially the defendant's company, which was taken over by through NCLT process by the new management of the plaintiff. Now, after taking control of the company, the man who is behind the new management approached the defendant that you are a rubber expert, so I need your expertise to develop this company for the plant, for rubber manufacturing plant. So you please join my company once again, the new company, new management, as a chairman, and give your what the knowledge, the expertise is shared with them. It was discussed as per the plaint runs that it was discussed that 7 other rubber expert persons will join the plaintiff together. Paragraph 4 of the plaint, it names about 7 persons who will join the plaintiff company so that they get a team. That is their case. Now, their father follows that by letter of 2nd of August 2019, my appointment was confirmed. But the plaint case runs and my financial terms, what extent of work that I will do, everything is recorded and signed by both the parties. So that becomes an agreement between the parties on 2nd of August. But that agreement does not mention, neither mentions the number of expert, nor mentions the name of the experts. I'll take the quote through that agreement later, but the agreement is silent. Then my appointment takes place. Plaint case runs that some payments were made to me on my appointment. The first tranche of the payment was made to me, but the other experts did not join. Even a period of 2 and 2.5 months when passed away, the other experts did not join. Paragraph 11 of the plaint says, out of those 7, 4 experts did join. That's the plaint case. It gives the name. 4 experts did join, but 3 others did not. So the entire 7 team, 7 plus 1, I am the number 1. The 7 plus 1, the entire team, as the entire team did not join. So paragraph 12 of the plaint says that my appointment did not take effect. Did not commence. My appointment did not take effect. That's the case. And they continue that your appointment did not commence, did not take effect. I have paid you 50 lakhs and odd. Return the money. TDS also deposited. So based on this, they make a claim of 55 lakhs. So 3-4 things from the plaint is that plaint case runs that I was supposed to join along with the 7 persons. 4 did join along with me. 4 plus 1, I am 5. Other 3 did not join. So my appointment did not fructify or did not commence. And I have been paid, return the money. My counterclaim is here, according to the written statement case. The written statement case is, there were some discussion with the main gentleman behind the new management, Mr. Hulani. All discussions were between the defendant, Mr. Thomas, and Mr. Hulani. Mr. Thomas was in the box giving evidence, but Mr. Hulani did not come. The evidence is not given by Hulani. My case in the written statement is, yes, there were discussions. Proposals were made for appointment of the entire team of rubber experts which are required to be done. But consciously parties did not put the name because I can only recommend the persons. They are not under me.
Most are the other persons.
Yes, I cannot, not slave. So I can recommend. So the terms and conditions, whether they are willing to join, the financial terms will all have to be independently agreed. I can only recommend. So the recommendation was done. 4% did join. The written statement case goes further in saying that in any event, my appointment was independent of the other experts joining. My appointment was separate. You paid me the portion of my salary, my entitlement initially. My appointment, my commencement of my service was independent from the other experts. I had a duty of recommendation, and then you will have to ask them to join the service. Moreover, that's my specific case in paragraph 7 of the written statement is, after joining the plaintiff company, I discharged my responsibilities in terms of the job profile. So I've rendered my service.
So there was an agreement, duly executed agreement,
My lord.
and the parties acted on it.
My lord. Parties acted on it. So far I am concerned to act on it is the
Fully
job
conscious of and understanding the terms and conditions on what they have to perform.
You paid money, I rendered my service. So action on your part, your payment of money, and my action on my part is my rendering you services. So my appointment is independent. I have rendered my services, and I have rendered my services for 4 months, August, September, October, and November. So for these 4 months, paragraph 10 of the written statement, for these 4 months, I am entitled to my remuneration of financial portions that is mentioned in the agreement terms of the contract. And that gives me the counterclaim with regard to my entitlement of my remuneration. And it is other things that I have, and I have rendered my expertise during this period. I've rendered your services. I have a rubber chemical expert in
Issue
the
is
field.
whether there is an executed agreement between the parties.
So these are the pleadings. Now, Lordship will come to the document. There's some documents which are important. There was one document which is Exhibit B, Exhibit A, judge's brief, whatever. There are two sets of documents which are draft agreements before the concluded contract. The draft agreements are Exhibit B. If my lord is looking at the instrument or the judge's brief.
Agreement, original agreement.
Or the final agreement is Exhibit D, page 21 of the judge's brief. The final agreement.
Then what is B?
B is draft agreement for discussion purpose. Lordship will see in the top it's mentioned. It is on 30th of July 2019. It's a predated. Page 2 of the judge's brief. Or the exhibit. Whatever.
Exhibit D টা কোথায় ওটা কোথায় judge's brief আছে?
Also next to the plain because it's a commercial.
Yes, Exhibit D is there.
Yes. So Exhibit D is the final document signed and sealed by the parties. It's signed by both the parties. Now this document is dated 2nd of August 2019. This is from the plaintiff company. This records, my lord, paragraph 1. Your appointment with the Mercom, the ML, as a business consultant will commence on your joining ML simultaneously with joining of the other experts from the rubber chemical field. Therefore, said experts will be selected and recruited on your recommendation and our approval thereof. These experts shall be absorbed for the smooth running of the business, and those experts shall be absorbed as a consultant on a permanent basis in the payroll. So here, the first paragraph records that the experts will be selected based on the recommendation by me. This document, paragraph 2 further records that I'm a business consultant with the designation of Chairman Emeritus of the plaintiff. And this position is offered to me and is exclusively solely in the capacity of a consultant that I will join the services. It further records that paragraph 3 about I have to visit the plant. Later there are other obligations clearly mentioned. I will have to visit the plant. Now, most important paragraph is here is paragraph 12. These are the confidential informations that will come to me. I cannot part with. Yes, paragraph 12 is the most important paragraph that this agreement contains the entire agreement between you and ML relating to the provisions of services and supersedes any previous understanding, commitment, contracts, representations whatsoever, whether oral.
There is no reference to any third party.
Yes.
And
First is
second thing, there is a very confidentiality of the agreement.
confidential of the agreement.
Paragraph 19.
Paragraph, yes, paragraph 9. I'll just come to paragraph 19, my lord. So paragraph 12 says, I'll tell you, because the plaintiffs is harping on some prior documents. Which
So
are
that will
unsigned.
not stand.
So this is paragraph 12 is this document becomes final. That's even the evidence case. That becomes the plaint case also. Paragraph 12. Then paragraph 14, my lord, is the financial part. With regard to how much money I'll get, 50 lakhs of rupees, whatever, the financial part. Paragraph 16 is my responsibilities. What will I have to do? Paragraph 16 is my responsibilities. Paragraph.
So whatever that might be, there is no connection with or reference to any third party.
Now, paragraph 17 is the compensation incentive. It says that I will be paid 1 crore 50 lakhs after your appointment as referred in paragraph 1. Paragraph 17, Roman 2. And out of this, 55 and odd was paid. This payment came on the very next day, 3rd of October. Sorry, 3rd of August. So on the very next day, this payment comes. So what falls from here, my lord? And Lordship may also see Roman 5. It says that when there is official tour, that I am entitled to the food and lodging and other, because I have a bill of that. Food, lodging and whatever. Paragraph 19, which fell from my lord, is.
So with all these things, you want to say that you have a right to claim.
I have a right to claim, and in this document, signed by the parties, the last page, what falls from this document, this is the final document between the parties, number 1, signed and sealed by the parties. Next is all previous understanding, oral, written is all given a go by. And third most important is, this agreement does not records. Neither it records the number of experts nor the name of the experts.
All right, come next day with your notes of argument. I got your points.
I will take your lordship. I'll come back on next day with the deposition, how the parties have. Or I'll come back on the next day.
No, let me see them.
So on this, and there are subsequent letters, then thereafter there are letters between the parties, the others did not join. I'll just show you the
Which questions you are referring to?
The plaintiff's question in the cross-examination. The plaintiff has proved that most important is the gentleman who deposed on behalf of the plaintiff is not the main man of this Thomas, because there are correspondences between Thomas and Holani. Holani is them. Now, Lordship will see the person who deposed is Mr. Unnikrishnan Nair. Now, he had deposed that these agreements are all exhibited marked. Now,
এটা তো ডিফেন্ডেন্টের সাক্ষীটা দিলে।
plaintiff.
Yes.
Now, I'll straight away take the code to question number 31 in the chief. The documents are exhibited. No, Lordship will kindly. Lordship will kindly see question 27. Question chief. Question 27.
Will be in a position to identify this document.
So it's Holani, the managing director of the plaintiff, issued this email. So these all emails are issued by Holani, the managing director. Even 28 is the email of Holani, the managing director. So whatever the correspondence on record is written by the managing director. This gentleman is not forthcoming to give evidence. Now, important is question 31. The appointment letter is also issued by Holani, the managing director, and P. Thomas. 31. 10 more minutes, I'll complete. So, 30, this is, the appointment is also given by Holani. The chairman, he identifies the signature. And this document is now marked as an exhibit. He makes the payment. Now the cross-examination. Now we'll kindly come to 63. In the chief only, he stresses on this agreement of 2nd of August. You have deposed today in your previous answer that there was an agreement between the plaintiff and defendant on 2nd August. Right. This is the final agreement. Have you disclosed this? We have disclosed this in the current proceeding. So he stresses on this instrument. Other documents are not important, but this, now the cross is important. There are few questions in the cross. Cross starts from 79, 80. Are you aware as to who were the persons in the board of directors of Merchem prior to Acmechem taking over? This is the previous management. 880. Basically, it was headed by P. Thomas and his family members. So we were the owners of the plaintiff company initially, before the present management took over. There was an independent director. 81 says, I say, is this P. Thomas the same person who is a defendant in the suit? Yes, he is exactly the same person who was the promoter of the at that point of time. Now, the next is that the name got changed. I think Merchem is now Finochem, so the amendment has been done. Now, my lord, will. Important is 84 onwards. Next 3-4 questions. As you deposed, the defendant was one of the promoter directors. No, yes. 85, my lord. And the defendant was subsequently employed in Merchem I believe there must be correspondence and negotiation between the two entities prior to the appointment. So whatever correspondence was there, they maybe have been disclosed in the plaint. Is it your evidence that other than the correspondence is disclosed in the plaint, there is no correspondence between the plaintiff and the defendant? Now the answer. Maybe. I do not know. Maybe personal communication was there between the plaintiff and the defendant. By personal communication between the plaintiff and the defendant.
So you want to say that the parallel understanding is not proved? Because this person is not aware of those things.
Yeah, this person not aware, this is not the best witness. He is not the best witness. Paragraph 8, question 87 says, personal communication between the managing director, Holani, and the defendant.
That is not proved.
That is not proved. What about the understanding?
And second point, if it is proved, had it been proved, whether it could have override the written contract.
No, it is not overriding, because the written contract is not naming any person. Written contract, why I am saying, kindly. The
written contract should overridden if this point is accepted.
Sorry, man. I'll just give me 1 minute. What I want to say is that the written contract is there. There is no oral evidence to that. Written contract is the final evidence, as written contract will speak for itself. Written contract. But I have rendered my service to the company. There are emails exchange, there are WhatsApp communication exchange between the parties, which shows that the defendant had rendered service. There are evidence to that effect. That when my witness was in the box, he has given oral evidence that what work he has done after the employment. There is no cross-examination.
Is there anything in evidence of PW?
PW, so there he admits that there are personal communication in 87. Now, 98, these emails, whatever on record, these are all from this email ID, Lordship will kindly mark, MD at Merchem. So, in 98, question number, the witness says that I have no access to that email ID. Whatever communication is from this email ID, MD at Merchem. And 100 is very important. Subsequent to signing of the agreement, there must be several meetings with Holani and Thomas. Maybe I am not privy to that. So this witness is not at all aware what happened after the execution of this instrument. Page 100.
So it is not proved by the plaintiff's witness that defendant neither rendered service nor avoided service.
Yes, my lord. And then the onus is on me. Then I will show from my.
He said, I am not aware of.
I am not aware of. And it was 102. And he,
Yes, I had
and he
noted this.
confirms the mobile number. This is my witness also confirmed, the Holani's mobile number. 102 appointment, no, I'm not aware. So he did not say that he did not render service. He said, I am not aware. 100 and 101, 102. 103 he admits there's some joint. That is different issue. Because joining is unimportant because I said that agreement did not mention any person. 100 and 102, this witness is not competent to give evidence. So these are now.
So according to
106 also.
Plaintiff's case is not proved.
106 also he said this is the final document. Exhibit D. When I put the question to the witness in cross, yes, it is the final agreement. So he admits this is the final document. So any prior document is obviously we cannot look into. So this is the case of the plaintiff's witness. So I say on this that the case run by in the plaint that the appointment did not commence
is wrong.
Is independent, and he says that no persons are mentioned. The document says that no names of any rubber experts are mentioned. And then I have to only show your lordship my deposition. If I can show today or on the next day, whatever. Defendant's deposition.
20-21 টা দেখো তো
20 টা খালি হবে না 20 টা বাদ দিয়ে যাবে মানে any day
21
any day
heard in part adjourned to 21st January. Basically, Mr. Mitra, what I feel, commercial matters are simpler. Because
commercial matters are simple.
It is based on contract.
Most complicated is eviction and probate.
Probate and eviction.
Eviction বুঝতেই পারেন কি আইন
Because you know, when there is a case of there is a suit for recovery of possession in lease matter, the first question will come up whether take a tenancy, whether this, whether that.
Which act? 56, 96, 97?
No, High Court,
1882?
we are not concerned with 56 or 96 Act.
At times defenses are taken. At times defenses are taken on this.
Then thicker tenancy comes in.
There's the one matter going on before us. Mr. Ghosh is arguing, I believe. Thicker tenancy comes in. Defenses are obviously taken of thicker tenancy and 56, the 56 Act, 97 Act.
That's regarding jurisdiction of
Issues are complicated. These are simply based on contract.
Issues are complicated.
Now, because of the Calcutta Thika Tenancy Act, the 2010 amendment, the issue whether a person is a Thika tenant or not has been given to the Thika controller.
That is now, so far as pending suits are concerned. No, now I have from 2010, 2011 to 20.
But earlier it was the old
Earlier it was
determination.
old suit. And some parted matters are there.
The old determination. Oblige.
Regular list.
But it will be 2 p.m. marked or normally in the morning, whatever.
2 p.m. 2 p.m.
Great.
Because if I start hearing an argument, other matters will be
In
filed.
the morning it will be difficult.
Item number 19, regular list.
21st.
The first matter that I had the opportunity to argue before my lord also contained the Thika tenancy point, Prachi Cinema Hall.
Yes.
My lord,
There you admitted that it is for commercial purpose.
my lord.
You are other side, other.
It was a plaintiff's case, yes.
There was an admission.
Yes. Now, my lord, in this particular suit, my lord, I am for the defendant. Defendant's witness was
plaintiff?
last in the box. My learned friend is appearing for the
For the plaintiff.
I'll just give a short overview, my lord. The scope of the suit is very short. The plaintiff had instituted the suit for recovery of money
I
lent
think
in
it should
advance.
go to commercial division.
It's a single instance, my lord. There are judgments which say single hand loan, my lord. It does not go to common. But I leave it to my lord.
No, leave it.
Very well, my lord. My lord, why I say the scope of the suit is very short? Because the suit was for recovery of money lent and advanced. 50 lakh was principal amount and the rest was, my lord, interest. Now, the plaintiffs took out an application, my lord, which was decreed. What was decreed was the principal amount of 50 lakh. So, I have already suffered a decree for rupees 50 lakh. Now, Interest portion was relegated to be tried under the suit. So interest portion, my lord, today we are only argument is only to the extent of the interest portion. Now, what happened, my lord?
Where is that decree?
My lord, I have
And
kindly
where is
take
that
the
order?
judge's brief once. All these orders are marked in the judge's brief. They have been exhibited also. Kindly takes the exhibit, the judge's
One
brief.
thing then,
My lord.
I think better you come with the notes of argument
Very well, my lord.
so that things will be easier.
I can do that.
I need not have to beat in the bush.
My lord will kindly give us in 3 weeks time because there are other
Not
issues.
3 weeks.
Because my client is out of station, my lord, he'll come
What
back.
you will do? You will study. It is not to be signed by any person.
Then may I just clarify one point before, my lord? Kindly seize the order. I'll just indicate why I am saying.
Come on the next date. Hard in part adjourned to 10 February.
Very well, man. I'm extremely grateful. I'll come with the notes of argument on
Yes.
I may like.
Witness action, item number 22. Bablu Hajra.
22, your lordship. I'm for the defendant. My client.
You are the plaintiff.
For the plaintiff, mother, you have give me a short password. Mr. Huda is appearing.
Your witness is there.
Has been going on.
Your witness is there.
Yes. Witness is only one thing.
Oh, he is there.
He's there. This matter was.
He is to be cross-examined.
Yes, he is to be cross-examined. This matter was going on in commission. Guess what? I'll tell your lordship. 65 commissions has been held. 65.
No, he came there here for examination of witness. No.
Yes, he's here, but let them finish because 65 hearings have already taken place in commission. Let him finish. Let Mr. Huda finish.
It is in commission.
No, commission was going, and then the.
It is an examination in commission.
Yeah, no. He's to be cross-examined now.
But let him come.
Yes, he is there. The witness is there.
Where is Mr. Huda?
He's on leg, mother. He's on leg.
Keeping it 5 minutes passover. Yes.
23.
Who is your other side, sir?
No, they are not appearing. On the last occasion, your lordship was pleased to pass an order
And what is one GA1?
that has been disposed of.
Now for argument.
Yes, my lord. It
ये
was-
बताओ तो document को बताओ तो. They adduced evidence.
No, nobody appeared. I have produced documents. I have proved them before your lordship. The will has been proved. Ordered copy গুলো দিন তো জজ সাহেব।
Power of attorney is not proved.
Lord, I was praying for your lordship's leave to place the orders passed by your lordship and the.
No, let me see the will first.
Very well, my lord. The will is Exhibit G.
Why these lease deeds are there?
My lord, first there was a lease deed. Then it was agreed that they will convey the property to me. But before that, this will was made. I will place both the documents in
Because it's a testamentary suit.
testamentary.
So we are concerned with the will only, whether probate should be granted or not.
That's right.
Why lease is, what is the relevance of this lease?
Because of the fact that relationship between the parties.
The testator had handed over possession to the petitioner herein.
Whether the will is valid or not,
That
that is to
that
be
is the only point. I was also, if your lordship takes the will at Exhibit J,
why death certificates are not marked.
death certificate is in the petition.
What is the name of the testator?
Girindra Kishore Pal Chaudhuri.
Yes, why it is not marked?
The there was no challenge to the fact.
This should be marked. No challenge means without any opposition, or in the other way of speaking, on admission. But this must be marked.
Very well, my lord. Your lordship can, if it is, it can be marked.
Death certificate, the original death certificate is annexed to the application.
Lordship.
This is a document issued by the public authority.
Lordship.
Since none challenged, just a minute.
Exhibit K, my lord.
No. What is this testimony of witnesses? Witness testimony to দাও। PW1 এর সাক্ষীটা দাও। How many witnesses? Executed and the
Three. My first witness was Tibeniasi. That means he was examined by commission, on commission. Second witness, attesting witness.
attesting witness, yes.
Rothin Shah. Evidence of Rothin Shah. He proved his signature to the will. And also of the other attesting witness. But he said that this signature was not in my presence in the will. Therefore, I took the advantage of Section 73 of the Evidence Act, and the will was proved. Your lordship will kindly come to the order.
What is Exhibit A? Is it will?
Exhibit A is power of attorney. That is PD2. Page 10 of the judge's brief of documents.
No, Exhibit A is another will.
Exhibit A is
will, another will.
will.
কোথায় এক্সিবিটটা কোথায় গেল?
আর কই একটাই তো will আমরা একটাই তো will আছে।
You go through the deposition, you will find it. The will is tender and marked with as Exhibit A.
Exhibit A. That is the Ranjusri Pal, my lord. If your lordship takes
J is will of Girindra Kishore Pal Chaudhuri.
Yes.
That is marked when the questions were from question number 44 to 49. This is will of Girindra Kishore Pal Chaudhuri.
That is your lordship is looking into the will of evidence of attesting witness.
Ranjusri Pal.
No, Ranjusri Pal is the applicant. If your lordship takes the evidence of Ranjusri Pal, my lord.
Who is the attesting witness?
Attesting witness is Mrs. Shah. Rothin Shah. He has declined to say that it was signed in my presence.
He was an attending witness.
Attesting witness.
Signed in my presence.
My lord, if your lordship will kindly go through the orders passed by the court from time to time.
I look into the evidence because I have to pass the judgment.
Right.
Whatever may be the orders.
Certainly, my lord.
আর ওখানে লিখে দাও, since it is unopposed, let the death certificate be marked as exhibit. Last was exhibit J.
Exhibit
Will was J.
K.
So
K.
exhibit H.
H-I-J-K it should be. H was the last will is tendered with, that is
K, sorry, K.
K.
Exhibit K, ওটাকে মার্ক করে দেবে। ডেথ সার্টিফিকেটে প্লেন্টের সঙ্গে আছে, এটাকে মার্ক করে নাও। Let me go through the evidence first.
Lordship,
A little bit confusing.
I can assist your lordship if you want to.
Let me first do it myself
Very well, my lord.
because things are a little bit confusing.
My lord, may I indicate to your lordship? First, a power of attorney was granted.
Death certificate of Girindra Kishore, কি নাম
Pal
দেখো?
Chaudhary.
Pal Chaudhary. Be marked as exhibit K.
First, a power of attorney was granted. That was 1st May 2000. Thereafter, a possession certificate was given by the testator in my favor, petitioner's favor. That is exhibit B. Then agreement for possession, exhibit C.
These are all irrelevant. I don't know why these were exhibited.
Because, my lord, to prove the signature. My lord, I am not a relation of the testator. But actually, the testator wanted to enter into an agreement with her, and he did. Agreement. There is an agreement which I have tendered for transfer of the property in my favor. Besides that, he only for the first floor. He entered.
Is it in Salt Lake?
Salt Lake. Well, now permission is not necessary. It can be on payment. The transfer is allowed.
All right, let me go through it. Let me go through the evidence. Come on the next step. Heard in part, adjourned to 7 February. Not 7 February, it's a Friday. Testamentary suit though. 11 February.
Well, I can, in the meantime,
Prepare a notes of argument.
Notes of arguments.
Referring to exhibit numbers.
Only
Exhibit
one
number
exhibit
and question numbers.
and question number. Exhibit number and question number.
Liberty is given to file notes of arguments. Mr. Huda, now come.
22.
Salt Lake properties, well,
I rejected one.
one gift, one lease, one rental agreement, one will.
Earlier, I refused one, Probate. Because when, as a lawyer, when you are producing something, you must apply your mind. You must remove all the blank papers, sign blank papers, you attached it.
And even more, if the will is executed earlier and these are executed later, then my operation of law, the will goes.
Complicated issues. Witness is there?
Yes. ওখানে যান না,
No, both to হয়েছে. Don't come with these documents. Keep it back. Is your name, sir?
Rubo Roy.
R-O-Y.
ROY. Sorry?
Spelling.
DHRUBA? Yeah, ROY.
He was partly examined.
This was going on in commission. Nearly 65 commissions has been held.
Now
There-
finish it. Cross-examination, finish cross-examination today.
Which one my management has used substantial time.
No, both you also.
That's not.
You finish it today.
I'll try not. Well, perhaps not will not be able to finish not, but I'll try as.
These cannot be dragged on.
I will just need one more day. One more day and I'll. Is there a specific time period within which is there
Mr. Ruda Phuket.
is there a specific time period within which the claim of insurance is required?
You're not audible properly.
Within which period?
You pull it near you, pull it a little bit near you.
Within which period a claim is required to be lodged with the insurance company from the date of the cause of action, comma, which in this case was the theft that had occurred on 2nd/3rd March 2012.
As per the timeline, loss need to be reported to insurance company to conduct the survey. Incident need to be have. In lost incident করে দিন. Incident need to be reported to insurance company immediately after. Reported to the insurance company immediately after the occurrence of the incident. That's it.
Can you elaborate the term immediate? Immediately, what is it? Elaborate the term immediately as used by you in answer to the last question.
Immediate means as per the policy, it is tentatively for burglary. As it was a case of burglary, it is tentatively for 7 days. Need to be reported. Immediately means tentatively within 7 days from the occurrence of the loss.
In this case, it is 7 days since it's a case of burglary.
Yeah. Oh, sorry. Mobile switch was.
Would I be correct in saying that the claim was duly lodged by the plaintiff within time as mentioned by you in answer to the previous questions?
Yes, claim was reported within the time frame.
Is there a specific time frame within which a police complaint is required to be lodged in case of an incident of theft For the purpose of
Mr. Huda, this will not do. Come little near the microphone.
too exhausted today. Perhaps that's the reason why.
You are not that amai. You are not that amai.
Yes. Exhaustion is being good. He had a very good day.
For the purpose of lodging and in claim for insurance.
Lodging of FIR is important as far as the burglary or theft is concerned. No specific timeline defined for lodgement of FIR. Defined.
So would I be correct in saying that there cannot be any dispute with regard to the lodging of the date of the lodging of the police complaint in the instant case?
No comments. Already.
Say yes or no. Give the answer.
Okay. Please repeat it again.
Would I be right in saying that there cannot be any dispute with regard to the date of the lodging of the police complaint in the instant case?
No.
How many surveyors in total were appointed in respect of the claim lodged by the plaintiff?
Repeat it again, please.
How many surveyors in total were appointed in respect of the claim? Were appointed. How many surveyors were appointed?
In this case, only one surveyor appointed. One surveyor was appointed. That is Cunningham Lindsay. Cunningham Lindsay. CUNNINGHAM. Cunningham Lindsay. LINDSEY.
Apart from Cunningham Lindsay, was there any other institution which was involved in the instant case vis-a-vis the lodging of the claim of insurance by the plaintiff?
Sorry. Cunningham Lindsay appointed to conduct the survey, whereas Integrated Insurance appointed to conduct the investigation. Further, CA Dilip Kumar Shah was appointed to cross verification of the forged accounting documents submitted by insured. Insured. INSURED.
He's PW1.
He is DW1.
Cunningham was appointed to conduct the survey, while is the integrated insurance appointed to conduct the investigation further. Dilip Kumar Saha was appointed to verify to make cross verification of the forged accounting documents.
Is it your evidence that Cunningham Lindsay, which was appointed as the surveyor, is it your evidence that the role of, is appointed as surveyor, did not include investigation of the claim lodged by the plaintiff.
As stated earlier, Cunningham Lindsay appointed as a surveyor and Integrated Insurance appointed as an investigator for evaluation of various documentation submitted by the insured. And further, the job of a Cunningham Lindsay was conducting the survey, as they are the IRDA license holder surveyor. They are the IRDA license holder surveyor. IRDA.
Question repeated, please.
Already elaborated.
Can you elaborate the term within quotes within investigation as referred to you in answer question number কত ও এটা তো আপনি বলতে পারবেন না এখন হ্যাঁ just previous question repeated to me. Repeat করুন.
As insured submitted various forged documentation in order to avail the insurance benefit with the intention to pilferage of public money, we as an insurer appointed to conduct the investigation, and which the purpose of the investigation was to verify the genuinity of the claim apart from conducting survey by respective surveyor. Cunningham Lindsay.
As so submitted various forged documentation in order to avail the insurance benefit that with the intention to encourage of public money, we as an insurer
With the interest to get the benefit.
Conduct the investigation, and the purpose of the investigation was to verify the genuinity of the claim apart from conducting survey by respective surveyor, that is
Is it your evidence that integrated services was appointed by the insurance company for the sole purpose of verifying the authenticity of the documents submitted by the plaintiff in order to process his claim for insurance?
Yes.
Did the insurance company obtain the consent of the plaintiff before appointing integrated services for the purpose of causing investigation?
It is the discretion of the insurance company whether they will appoint investigator or not. So no consent need to be obtained from insured.
Are you in a position to produce the original insurance form which was filled up by the plaintiff at the time of availing the insurance policy?
Currently not, as these claims pertain to 2011-12. So we don't have currently we don't have available this document. Pertains to 11-12.
Is it your evidence that in respect of an insurance claim pertaining to the year 2011-12, for which an insurance claim was lodged on 5th March 2012, and a suit was filed in the year 2015, the defendant was not the insurance company was not required to retain important and relevant documents?
Here, as far as the proposal copy is concerned, it is immaterial in continuation towards the fate of the current claim is concerned. I'm saying a question tag to repeat, please.
Include evidence that in respect of the insurance claim pertaining to the year 2011-12, for which the insurance claims was lost on 5th March 2012, and the suit was filed to the year 2015. The insurance company was not required to retain important and relevant documents
pertaining to the claim. Documents pertaining to the claim.
In continuation, the proposal form policy copy has already been issued and which has been served to the insured. Sorry. In continuation with the proposal form, policy copy has already been issued and subsequently served to the insured. Thereafter, claim has been lodged and same has been declined by insurer, mentioning same as a fraudulent claim, keeping in view of the various documentary evidence. Therefore, referring proposal form is here at this context is immaterial.
My specific question to you was in respect of retention of important and relevant documents, in light of such query, can you now answer the previous question?
Already replied.
I suggest to you that you are intentionally not bringing on record
Bringing on record
the insurance proposal form since the production of the same would go against the case made out by the insurance company.
Proposal copy.
First you agree or disagree, then give your answer.
I strongly disagree. Copy of proposal form is not going to slowly বলছি copy of proposal form আমার এটা তাহলে ওই হয়ে যাচ্ছে copy of proposal form is not going to create any sort of impact towards the fate of the current claim. Rather, we are of the opinion that you are unnecessary.
Copy of proposal form has no bearing on the present claim.
Yeah.
Rather,
yeah.
Then
Sorry.
Continue.
A copy of the proposal form no bearing towards the
Yes, then rather
fate of the claim. Rather, you are trying to defend the unjustified.
Not you, rather the plaintiff.
Plaintiff is trying to justify. Plaintiff is trying to justify his claim, which is not tenable in the court of law.
Would you agree with me that the plaintiff had duly replied to the queries raised by Cunningham Lindsay with a letter dated 27th March 2012 by the response dated 1st April 2012?
Now show me the documentation then.
For documents.
My lord, these questions have been asked. These questions have been asked on many
several
occasions.
times.
Again and again, these.
Why are you repeating this, Mr. Dhuda?
Not asked, my lord. Not a repetition, my lord.
Survey appointation, investigation. This question I have already.
Everything has been asked.
Now, issue of is that this is a cross-examination. If a question is asked 3 times and 3 different answers come out, that will undermine the veracity of the witness. Please be continue. Finish it. How long would you take?
I'll take some time.
Next day I will finish or I will close it.
I just need to give
My
suggestions
lord.
now. So far as my lord the
Please.
I just need to, my lord, give suggestions.
Give
My
the
lord,
suggestions and finish it today.
today it will be, my lord, a bit difficult on my part.
Next day I will give you 10 minutes time.
More than enough.
All right. DW1 is cross-examined in part.
This answer.
Yes.
Question that
We leave it to your lordship, my lord. The last
We can retain this question. This question may be retained. Last question may be retained. What is the answer?
Now I have to see that
Question to back out.
What's the page number?
You need to answer. Or you can say that I will check and answer on the next occasion.
First, I have to check that what are you raising the query. I'm not able to understand what
They
your
will
query.
send. Pull it.
That is, I'm hearing that will show me that later what he has responded.
এক্সিবিট কত বলো না, এক্সিবিট কত আছে? 12 টা এক্সিবিটটা বলো তো, এক্সিবিটের কাছে দিচ্ছি।
Further cross-examination is referred to. February 12th.
That 12 February.
Any problem? Prepone or postpone?
Kindly postpone your lordship. I think
Postpone.
something else.
Or prepone? 31st is okay. 17th February?
17th February.
17th February.
Is my lord desirous of fixing a time?
2:30 after 2 p.m.
After
It is always after. Yes, after 2 p.m. আরে ও তো ক্রস হচ্ছে, চিফটা হয়নি, ওত করে দিয়ে দাও, ওত করে দাও, ওত করে দাও।
I solemnly inform
That whatever I depose
that whatever I depose
by way of evidence,
by way of evidence,
I shall speak the truth.
I shall speak the truth.
No part of it shall be false,
No part of it shall be false,
and I shall not conceal anything.
and I shall not conceal anything.
What is your name?
Dhruva Roy.
Dhruva Roy. Father's name?
Let Devi Prasad Roy.
Devi Prasad Roy.
BI, P for Bombay.
Your age?
46.
Occupation?
Service.
Confidential address.
7V, V for Victory.
7V.
MD Lane, Chitla, Kolkata 27.
$24.
Advocate probably asked me to tell you, to inform you, Lordship, that most of the time.
Yes, they have taken most of the types of cross-examination. They have taken, my lord. If you
All right, all right. I will decide it at the time of finally passing the judgment.
143.
You just ascertain the percentage or share of your delay. I will put cost accordingly. Cost will be divided. If you are 60%,
No, already paid.
once again you will pay.
Already paid to the Landed Commissioner appointed 10 lakhs.
Once again you will pay to the High Court Legal Service Committee, if necessary.
To the plaintiff, my lord. To the plaintiff.
Both. According to share of delay.
My lord will decide the suit. My lord will decide after hearing the evidence. 143 tons of pesticides disappears in 2 hours in a night. It takes about 12 lorries. It disappears in 1 hour. No one sees anything. Now your lordship will decide. 143 tons of pesticides.
17 scientists were removed from Pakistan nuclear arsenal, nuclear point. The 17 scientists were removed without any trace, without any single fire. And that was the protected enclosure. How they escaped? How they were kidnapped? That question is raised by Amnesty. Whether they were kidnapped or taken up by military. So it's like that.
On fact, it was not, my lord,
fertilizers, my lord, pesticides, my lord.
Pesticides, whatever.
It was seasonal crops. So the facts following it, your side.
24.
Yes, come.
Going on, last occasion. I will for the defense.
You are here.
Best start.
আমার নাম হচ্ছে মিরাজ রশিদ, MERAJRASHID.
Mr. Rashid, last occasion, in answer to question number 20, you have answered, we have made an agreement about renovation charge that is at page 13, memo of consideration of leave and license agreement. What did you mean to say?
যখন আপনাকে জিজ্ঞেস করেছিল agreement হয়েছে, after the agreement was executed, what happened with regard to the lease and license agreement and so for operation of the commercial space টা কি হয়েছিল, license agreement এর পর আপনি বলেছেন we have made an agreement, আমরা একটা চুক্তি করেছি about the renovation charge. That is at page number 13 of the memo of consideration of the lease license. এটা কি বোঝাতে চেয়েছেন? আমি আগে থেকে একটু যদি বলি, অসুবিধা নেই তো। আপনি কি বোঝাতে চেয়েছেন বলুন। লর্ড, আমরা একটা লিভ এন্ড লাইসেন্স করেছিলাম 1/1/2014-তে। 60 মাসের জন্য 60 months.
For a period of 60 months. With whom?
With Mr. Mohammed Nasim.
With Mr. Mohammed Nasim, the defendant herein.
Yes, my lord. আর পিরিয়ডটা এন্ড হচ্ছিল 31/12/2018.
The period was to expire on, it was till
31/12/2018.
That means it will come into end from 1st January to 2019.
18, my lord. 31/12/2018.
That was the last day.
Yes, my lord.
So from 1st January 2019, it is not.
No, yes.
It was about to expire on 31/12/2018.
Exhibit B check.
যেহেতু মাই লর্ড ওই জায়গাটা আমার নিজের, আমি ওটা নিয়েছিলাম একটা গেস্ট হাউস বানাবার জন্য। গেস্ট হাউসের টাইটেলটা ছিল, নামটাই ছিল হোটেল ডিউক। The place was mine. I have taken the place to make a guest house there. The name of the guest house was Hotel Duke. Duke, D-U-K-E. Duke.
Kindly have a look to the agreement and tell my lord what is the contents of this agreement.
What this document is?
It's a leave and license, my lord.
Between whom?
Between me and Mr. Mohammed Nasim.
This is a leave and license agreement executed between me and Mohammed Nasim, the defendant. Do you admit this document? Do you admit this document?
Yes.
Execution is admitted.
I also rely on it.
You mark the signatures.
Signature of the plaintiff has been already. Signature of the plaintiff has already been marked, but so far the signature of the defendant has not yet been marked.
Defendant signature, mark the defendant signature.
That's exhibit B, my lord. It's already been marked. The agreement is exhibit B.
Document is exhibited.
Document is exhibited, but so far the signature of the defendant, that is not marked.
This is your signature, defendant.
Yes, my lord.
He is the plaintiff.
Do you know defendant signature?
হ্যাঁ, এটা অপোজিশন যে আছে ওনারই সিগনেচার।
Identify and mark it.
The signature of the defendant.
With blue pencil, mark it with blue pencil.
আমি তো ব্লু আমারটা করেছি, এটা করবো।
ব্লু দিয়ে করবে।
মাই লর্ড, আমার সিগনেচারটা আমি ব্লু দিয়ে করেছিলাম।
This may also.
ওকে মাই লর্ড।
Red will be used to mark it.
Yes. But it is already marked as Exhibit B, my lord. Mr. Rashid, kindly come to internal page 5 of this agreement.
Yes, sir.
Kindly read the clause 5.
Arch number cross check.
The license will pay the licensee a sum of rupees 30 lakhs only as per memo given hereunder as an account of renovation cost.
And then renovation cost
of the hotel premises.
Did the defendant paid the said rupees 30 lakhs towards renovation cost as per this agreement?
Defendant কি এই চুক্তি মোতাবেক 30 লাখ টাকা দিয়েছিল রেনোভেশনের জন্য?
My lord, উনি 20 লাখ টাকা দিয়েছিলেন। তারপর আর তারপর উনি আমাকে দেননি কোনো টাকা।
Since the defendant did not pay the balance amount rupees 10 lakhs, then what did you do?
My lord, ওনাকে আমি অনেকবার ফোন করেছিলাম, কিন্তু উনি একবার ফোন তুলেছিলেন, তুলে বললেন যে ঠিক আছে আমি যাব আপনার ওখানে, and আমি আপনার সঙ্গে যে কথা বলে নেব।
I will have a talk with you. I would have a talk with you.
Upon payment of rupees 20 lakhs by the defendant to you, did you make any renovation work in respect of the hotel business premises?
What did you do with this 20 lakh rupees?
ওটা আমি ওর রিনোভেশন কাজের জন্য আমি লাগিয়ে দিয়েছিলাম।
Don't make a leading questions. Questions may be framed differently.
As you lord. Since the defendant did not pay the balance amount rupees 10 lakhs as per this agreement, did you take any step, writing letter or any suit?
Once again, you are making leading question. What did you do for the rest of the money?
My lord, আমি বলি আমি 20 লাখ টাকা ওনার কাছ থেকে নেওয়ার পর থেকে রেনোভেশন ওয়ার্কটা চালু করেছিলাম।
After getting 20 lakh from I started the renovation work.
তারপর ওনার 10 লাখ টাকা দেওয়ার যেটা কথা ছিল, উনি বললেন আমি এসে দেখে আমি দিয়ে দেবো।
After that, he said that the rest of 10 lakhs amount that had to pay, he said that he will come give it us and give it to us, give it to me.
কিন্তু উনি এসে উনি এলেন, এসে দেখে বললেন আমার কাছে এখন পেমেন্ট কম আছে, কিছুদিন পর আমি পেমেন্টটা দেবো। আপনি চেকটা আপনার কাছে রেখে দিন, আমি বলবো, তারপর আপনি চেকটা ব্যাংকে ইস্যু করবেন।
Did you encash that check after sometimes or as per his request?
নো মাই লর্ড, ওনাকে বলার পরও উনি একটাই কথা বললেন, ফান্ড আমার আসলে আমি আপনাকে জানাবো। ফান্ড অ্যাকাউন্টে আসলে এইভাবে 3 মাস ক্রস করে যায় আর চেকটা ভ্যালিডটা শেষ হয়ে যায়।
Then what did you do?
তারপরে আমি ওনাকে একটা চিঠি পাঠালাম 3/3/2014-তে।
I'm showing you one document. Kindly tell my lord what is this document about?
মাই লর্ড, এইটাই হচ্ছে ওই চিঠিটা যেটা আমি মিস্টার মোহাম্মদ নাসিমকে পাঠিয়েছিলাম।
Document dated 3rd March 2014. That letter which I sent to Mohammed Nasim.
মোহাম্মদ নাসিম।
By this letter, what did you say?
আমি ওনাকে বলেছিলাম যে 10 লাখ টাকা আমার দিন, কেন রিনোভেশন ওয়ার্কটা বন্ধ হয়ে যাবে। আমি প্রথমেই বলেছিলাম আমার ফিনান্সিয়াল
Later, I asked for the balance 10 lakh rupees from him. I also said, I told him that the renovation work would be stopped if the money not given.
তারপরে উনি রেগে গেলেন আমার উপরে। আমি ফোনে বললাম ওনাকে, যে আমাকে জিজ্ঞেস করছে আপনি চিঠি কেন পাঠালেন।
But Mr. Nasim, Mohammed Nasim asked me, why have you issued a letter? He got angry.
তারপর উনি একদিন আমার জায়গায় এলেন, বললেন আপনি আমাকে চিঠিটা লিখলেন, আমি বলেছিলাম পরে পেমেন্ট করব, আপনি চিঠিটা ইস্যু করলেন।
He visited me for once after that and asking why I have issued this letter. Say that he will make the payment afterward.
How this letter was sent to him?
এটা বাই পোস্টালে পাঠিয়েছিল মাই লর্ড।
I've also shown you another document which is attached with this letter.
দেখি ডকুমেন্টটা।
Kindly tell my lord what is this attached document?
The document attached করা আছে সেটা কি
কোন
document?
ডকুমেন্ট? এটা পোস্টাল কার্ডটা।
Is there any signature in the document?
এই document এ কোনো সই আছে?
Yes my lord, এটা আমার সিগনেচার।
Yes, there is a signature of mine.
Who typed this document?
Document কে টাইপ করেছে?
মাই লর্ড, এটা আমি একটা লয়ারকে দিয়ে করিয়েছিলাম।
টাইপ কে করেছেন?
এটা বাইরে দিয়ে আমি টাইপ করিয়েছিলাম।
The letter was drafted by one lawyer and typed by a stenographer outside. Have you gone through the whole letter? Do you understand the letter? What is written in it?
হ্যাঁ, ওইটা ওই 10 লাখ টাকা দেওয়ার জন্য আমরা।
Do you understand the contents of this letter?
Yes my lord.
I do understand the contents of this letter and put my signature after understanding the same. Encircle the signature with blue. This is the postal receipt.
Yes, my lord.
ডকুমেন্টটাকে মার্ক করো, কি করবে?
Exhibit C.
Signature C by 1 and postal receipt C by 2.
With objection.
Why objection?
If the contents had not been.
He said he is the author of the. He said
Yes,
I
yes,
understand. All right,
Whatever the
objection.
contents. With objection, Lord. Fine.
Mr. Rashid, did the defendant make payment after receiving this letter?
এই চিঠিটা পাওয়ার পর কি ডিপেন্ডেন্ট
আমার লর্ড কোনো পেমেন্ট দেয়নি।
In response to the letter written by you, dated 3rd March 2014, addressed to the defendant, did the defendant took any step against you or issued any letter?
3রা মার্চ 2014-তে আপনি যে চিঠিটা পাঠিয়েছিলেন ডিপেন্ডেন্টকে, বিবাদী পক্ষকে, তার এতে পদক্ষেপ হিসাবে উনি কি কিছু করেছিলেন?
হ্যাঁ মাই লর্ড, উনি চিঠি পাঠিয়েছিলেন আমাকে।
He has sent me a letter.
I'm showing you one document. Kindly tell my lord, what is this document about?
এই ডকুমেন্টটা দেখুন এবং মাই লর্ডকে বলুন এটা কি ব্যাপার।
মাই লর্ড, এটা ওই সেই ডকুমেন্টটা যেটা মোহাম্মদ নাসিম আমাকে পাঠিয়েছিলেন আমার চিঠি পাঠাবার পরে।
Is there any signature?
Yes, my lord.
Whose signature is it?
My lord, Mr. Mohammed Nasim's signature.
Inside, do you oppose? Do you oppose?
Lordship, no, this is the my document.
Signature be encircled with blue pencil.
আমার চিঠিটা তো
The signature of Mohammed.
D by 1. Last one was C, so it will be D and D by 1.
Document D, signature to the divide.
Kindly go through these contents of the letter and tell my lord what is the gist of the letter.
এটা পড়ুন এবং মাই লর্ডকে বলুন চিঠিটার ছোট্ট করে বিষয়বস্তু কি।
মাই লর্ড, উনি বললেন যে ঠিক আছে আমি 20 লাখ টাকা দিয়েছি, 10 লাখ টাকা আপনাকে তখনই দেবো
Mohammed Nasim told that he has paid me out of rupees 20 lakhs and he shall pay the rest of 10 lakhs.
আপনার টোটাল রিনোভেশন কাজটা করে কমপ্লিট করে আমাকে হ্যান্ড ওভার দেওয়ার পরে আমি 10 লাখ টাকা দেবো।
Once the total renovation work is completed and it is handed over to him. The hotel actually.
Exhibit করছি না? Then what did you do?
এরপর আপনি কি করলেন?
মাই লর্ড, ওনাকে অনেকবারই বললাম আমি পেমেন্টটা করার জন্য, কিন্তু অ্যাজ পার
Several times for looking for to make the payment.
কারণ যেহেতু আমার ওই জায়গাটা পড়েছিল, আমি একটা লিভেন লাইসেন্সে 2,20,000 টাকা মাসে পেতাম। আমি প্রথমেই জানিয়েছিলাম আমার ফিনান্সিয়াল কন্ডিশন ভালো ছিল না।
কি পড়েছিল?
আমার ওই কমার্শিয়াল প্রপার্টিটা পড়েছিল।
Because I could not commercial property.
2,20,000 টাকা লিভেন লাইসেন্স ফিটা পেতাম আমি। কিন্তু উনি কোনোভাবে আমাকে কিন্তু পেমেন্টটা দিল না। প্রত্যেকবারই একটাই কথা বলতো, আপনি করে কমপ্লিট করে আমাকে দেবেন।
Every time he said that once the renovation work is completed and it is handed over to him,
তারপরে উনি টাকাটা দেবেন।
Apart from the raised amount of rupees 10 lakhs regarding renovation cost, did the defendant paid any leave and license fee monthly since the
Are
inception
you
of this?
cross-examining?
No, my lord.
Come on the next day, get prepared for examination in chief and then ask questions. You are DW1.
PW1.
PW1 is examined in chief in part. Further examination in chief is referred to, give a date. This is not the way of examination in chief. 11 February.
Item number 25.
Where is the witness?
For the plaintiff.
He was waiting outside. Kindly allow Mr. Doctor to my lord. Give me my lord.
In fact, I have number of witness actions today. That's why things are delayed. Now thereafter I have to take up company matters. Who is the witness?
The time before, yes, I took on. फिर आगे हो तो चलो.
What is your name, sir?
Deepak H. Doshi. DIPAK.
Doshi? D-O-S-H-I.
Correct.
Yes.
Mr. Doshi, kindly take a look at this document. Kindly take a look at this document, original document. Copy whereof is appearing at page 100.
What this document is about?
So this is the complaint which was lodged by Mr. Vikram Harish Metramani.
That is brief.
Metaramani, wherein he has lodged a complaint about the unpleasant incident that had happened in the Saturday Club.
A little bit low, slow.
Sorry, my lord. The Christmas Eve celebrations on the night of the 24th December 2019 within the premises of the Saturday Club, Kolkata. Wherein, my lord, he is alleged misconduct on behalf of Mr. Keshav Bhajanka, who allegedly abused him and thereon physically assaulted him.
How did you receive this document?
In my usual course of business as the then president of the Saturday Club.
Mr. Doshi, can you recall when you had received this document? Copy whereof is appearing at page 114 of the judge's brief of documents.
This was received by me. This was Christmas celebration week. I was there during Christmas celebration week.
Can you tell me the date?
26th of December, my lord.
That was the question to be answered. This complaint was received by me on 26th December 2019.
19, my lord.
When?
During the day,
In course of the day.
in course of the day.
Mr. Doshi, your lordship, may this document be tendered as exhibit.
Lord, you sit here. Go and sit here. Take seat there.
Not true. Subject to objection, my lord, not true. My lord, not a single.
May I know what the document, what's the objection is?
On objection.
On objection.
Mr. Doshi, kindly take the original of this document, copy whereof is appearing at page 117 of the judge's brief of documents. Please tell my lord, what is this document about?
This document is the complaint received from Mr. Keshav Bhajanga as regards the same incident where he counter-alleges that he was abused by Mr. Vikram Metharamani. And thereon had physically assaulted him. He also mentions that he had filed an FIR on the same subject and had requested the management committee to take suitable action.
How did you receive this document?
Also in regular course of my business as president then.
Your lordship, may this document be tendered as exhibit.
On objection. On objection.
This one I'm not.
No.
What happened thereafter, Mr. Doshi, after you received all these complaints?
Thereafter, it was Christmas week, so we could not take any immediate action. We could not take any immediate action. But there was a lot of talk about it in the club. It was a burning issue. Yeah. But sometime in the second week of January, if I recollect, members of the General Committee had spoken with members of the balloting committee. Had spoken to members of the balloting committee, wherein we decided to deliberate on the issue and convene a membership committee meeting on the 16th of December. I'm so sorry, 16th of January. January 2020.
Is your answer over?
Yeah.
Can you explain the composition of the membership committee that you just referred to in the answer to the previous question?
We have a general committee which consists of 10 members, and we have a balloting committee which also consists of 10 permanent members in both the cases. 10 permanent members in general committee, 10 permanent members in balloting committee.
Both the members are permanent members.
Sir, your lord. And together, the 20 such permanent members comprise the membership committee, which is essentially called upon whenever there is a disciplinary issue.
Then what did the membership committee do?
Having taken exception of the incident, we decided to convene on the 16th of January to deliberate upon the matter. I'm sorry. So the membership committee decided to deliberate upon the issue and convened a meeting on the 16th of January 2020.
What happened in the meeting of the membership committee, which was held on 16th January 2020, which you just referred?
We had other agendas and matters to be discussed. And this incident was also brought to light in the membership committee meeting.
Mr. Doshi, please take a look at the original of a document, copy whereof is appearing at pages 141 to 144 of the judge's brief of documents. And please tell my lord, what is this document about?
These are the minutes of the membership committee meeting, which was held on 16 January, as I just mentioned.
Can you tell my lord, whose signature do you find at the bottom of every page of this document?
Those are my signatures as the then president of the club.
Is there any other signature appearing on this document?
On the last page of the minutes, that of the secretary, Colonel Jha at that time.
How do you know the signature of Lieutenant Colonel Rakesh Kumar Jha?
I know it. He was with us in the normal course of business. I know it to be his signature.
Mr. Doshi, what?
You encircle those signatures with blue pencil. Signatures collectively and the document individually marked as exhibit? 6. He is defendant witness.
Yes, Your Lordship.
6 and 6/1 collectively.
Signature 6/2.
6/2.
The document also, Your Lordship. Subject to objection.
Subject to objection.
This document subject.
Your lordship may.
Love's objection. Why are you standing on the way?
6 by A, 6 by B.
6 by
Collectively.
6 by B.
Signature 6 by D.
This much, Mr. Dotto.
Very well, your lordship. Your lordship, only one question. Only one question, your lordship. Have I asked what do you have to say about the contents of this document? No. What do you, doesn't matter.
What do you have to say on the contents of the document?
So like I said, the contents of this document, we deliberated upon other agendas, and we also discussed the incident wherein it was
So
definitely.
the contents of the documents are outcome of the discussions and deliberations.
They're true and correct.
The contents of the documents are outcome of deliberation and discussion in the committee, and they are true and correct.
Your lordship may it be marked without objection since I've asked this question. Now, if my learned
There
friend
is
wants to-
objection.
Very-
DW1 is chief or cross?
Chief, your lordship.
Examined in chief in part. Further examination in chief is deferred to 12th February.
My junior's getting married.
Which date?
After the 15th, any date in February after the 15th.
1920? 19 February.
19 February. 19 February.
Have you any preoccupation on 19?
So I would be traveling, but I'll make the necessary arrangements.
20?
My lord to be present.
20?
My lord, I'll be here.
20 you are here.
That week, I'll be here. That week, if it's an earlier date, suits better, sir. Suits better, my lord. But 20th, my lord, is also fine.
17, 18 or next week prior to that.
20th, my lord, is also fine.
20th. Yes. You may go.
Company matters. Item number 26.
DK India Limited.
Lordship, for item number 26, I'm appearing on behalf of the official liquidator. I'm led by my senior, Mr. Ronojit Chaudhary. He's doing extremely unwell, so he could not appear before your Lordship. However, I've been
Adjourned to
instructed.
10 February.
Lordship, I've also been instructed by my senior that in the last occasion it was ordered by your Lordship that the official liquidator appoints an auditor in this respect, and the auditor has been appointed on 19th December 2024 itself, your Lordship. However, Lordship, the auditor.
Come on let him come. Come on the next day, I will check it.
Obliged, your Lordship.
Next.
27.
And for the official.
Wait, please, my lord. This is my application, my lord, seeking, my lord, dues towards security expenses, which, my lord.
My lord, on the last occasion, yes, my lord, on the last occasion, there was a direction to file a report giving the details about the security asset. May I hand up a copy of the report?
The learned official liquidator submitted a report showing that a a sum of rupees 27,92,084 is at hand. What is his due?
He will be entitled to get that 45, no?
Around 54 lakhs.
No, not 54, my lord.
Little more, I'll tell you.
Because the total payment
45 lakhs, 47,000.
present rent in hand with the official liquidator as on 30th of November 2024
is 6 crores 19 lakhs. If your lordship kindly comes to
So
page
what is
3,
this 27 lakhs?
27 lakhs. That is the actual, that is the, if your lordship kindly sees, paragraph 7 I have indicated.
Yes, 27 lakh
Yes.
92,084.
That is the already it has been payment earlier, my lord.
So total, what is the amount in hand? 6 crores.
6 crores.
So what do you have to say on payment of paying him?
We can pay him. Right, pay for the- Yes, we
this-
can pay.
This kind of an order was already passed, my lord. Once kindly takes annexure 9.
Should I have to
page
follow
9.
the earlier order without irrespective of any objection raised?
No, my lord, that is not, my lord, my contention, my lord. What I'm trying to tell your lordship is, my lord, payments with
What I want to know is the objection, what kind of objection, if any, raised by the
We are
official
not
liquidator.
raising any objection, my lord. Your lordship kindly
Let me
comes to
know
the
that.
annexure A, my
If you
lord.
feel some other order will help you, just get it typed, show them that order will be passed. Don't bring it to me. If you think you will decide the matter.
My apologies.
No, when we are not standing in the way, then an
That is
order
one
can be
thing.
passed. Yes.
That is one thing.
Kind of bullshit.
AO কোথায়? Have you filed any AO?
No, no, only the report, my lord. There was only direction for a report, for filing a report. If your lordship kindly takes up annexure A, my lord, we have indicated the closing balance. That is the amount which is lying in our hand.
কি বললাম dictation কি দিলাম? না, fresh লিখুন. The learned official liquidator submitted report dated 14 January 2025 pursuant to the order passed by this court on 2nd December 2024. First up, the report shows a sum of rupees 6,19,36,865.76 paisa in hand. Who is he making claimant?
This is the security expenses, man. On
No,
account of
who
the
is he?
security. He is appearing on behalf of the security.
No, my lord, I am appearing on behalf
Who is the applicant?
My lord, I am
The
my lord,
applicant, my lord.
manufacturers.
Who is the applicant?
Association, Manufacturer Association.
What is the name of the association?
Behala West RIC Industrial Estate Manufacturers Association.
Is the claim genuine? What is say your
Yes,
report
my
says?
lord. Yes, my lord. On the, they have been, because from paragraph 7, my lord, we have already paid them 27 lakhs. From 2008 onwards, the official liquidator has made the payments. Paragraph 7, my lord.
It is further stated in the report that subsequent to an order dated 7/1/2014 passed by this court in CA number 348 of 2010, security expenses were reimbursed to the present applicant, namely Behala West bracket RIC Industrial Estate Manufacturers Association since 2008, amounting to rupees 2792.84. Full stop. Next paragraph. What is the claim of the present petitioner?
45 bullet.
45 lakhs, 47 lakhs, 45 lakhs, 47 lakhs, 173, 47,000. My apologies.
Present claim of the official of the applicant is 45, 47, 163. Full stop. Fund in hand of the official liquidator is sufficient to reimburse this cost, this claim. Oh,
My lord,
Explain.
to reimburse the security expenses. Kindly makes it clear.
on account of security expenses. Let the official liquidator pay the sum of rupees 45, 47, 173 to the petitioner out of the fund available to him, and shall submit a report in this regard on the returnable date.
My lord, within 2 weeks we shall reimburse.
Let the matter appear in the list.
Because these are all in a
26
fixed deposit, it needs
26
to be
February.
encashed.
26 February.
February. Yes, madam.
One thing, my lord.
CA 64. This is 64.
Yes, my lord.
CA 64 of 2024 stands disposed of accordingly.
My lord.
No, let it be kept pending. After submission of report, I will dispose it up.
Then may I come back with a compliance report?
Yes, yes.
My lord, CA60 is my application. It's an application taken out by the joint special officers appointed by this court in respect of the Bonugli unit.
Which one that?
By CA60.
It's not appearing in the list.
It's not appearing in the list today. It is 64.
It's only 64 appearing.
Then let CA60 appear along with it on the next day.
ওটা দিয়ে দেবে। না, না। এটা নিয়ে নাও।
28 Rose Valley Patrika Limited.
Well, this is an application taken out by the official liquidator. Your lordship kindly takes up the summons. This is for appointment of an advocate in respect of filing the misfeasance application. That is an application against the delinquent directors under section 543, my lord.
Where is your prayer?
Summons for direction. It's for appointment of an advocate from the panel to initiate the misfeasance process. On earlier occasion, there was a direction for appointment of an charter accountant to
You have to
file
ascertain
a
whether
investigation.
your fund is enough to bear the legal expenses.
ঠিক আছে কি fund? Fund আছে কি? It doesn't have any fund. So then it has to be taken care from they have to take a loan from the OL establishment fund for meeting the.
So you have to propose that.
Yes, my lord. So A and B, my lord.
But before that, you have to make a proposal that we have to borrow fund.
My lord, if my lord,
Or I can
direct,
ask for
because
a-
I have also prayed for, it's prayer B, my lord. If prayer B is allowed, then it covers.
Submit a report. 7 days of time. I'm giving you 7 days time. Come with a report. GA CA 8 of 21 is filed by the learned official liquidator, praying for leave to appoint an advocate, appoint an empaneled advocate to initiate misfeasance proceeding against the ex-directors to incur expenses by the official liquidator relating to payment of fees to the advocate along with other prayers. The learned official liquidators shall submit a report on status of fund available for this purpose. Report shall be submitted on or before the returnable date. Let the matter appear in the list on 30th January.
Fund in respect of this company and liquidation.
Available fund. That will be enough.
Since there is no fund, so my lord, on
You
the
come
basis
with
of
a
the
no
report,
fund and
yes,
come with a proposal also.
proposal of taking loan from the.
Yes.
Deeply obliged.
29
Lordship, I am appearing on behalf of the official liquidator. This is an application for appointment of an auditor, Lordship.
Appointment of?
Auditor, Lordship.
Auditor?
Yes, Lordship.
Who is auditor? Whose name you have proposed?
Lordship, from the panel, Lordship. We have not mentioned a specific name, Lordship. It's a panel of an official liquidator. If your Lordships kindly come for someone for direction, I am praying for an order in terms of prayer A, B, and C, and Lordship. We have a panel of valuer, Lordship.
CA number 5 of 22 is filed. Praying inter alia for appointment of auditor, appointment of empaneled auditor, to conduct investigation by the appointed auditors and submit report along with other prayers. For the time being, let an empaneled auditor be appointed. No, before, what is the status of your fees, of your fund?
Nil, Lordship.
So you have to come just like a previous one, you have to come before passing any order on CA. The official liquidator shall submit a report on availability of fund for appointment of the valuers, auditors,
Auditors, Lordship.
with proposals. Let the matter appear in the list on 14 February.
Lordship, one thing, Lordship. The prayer D, I have already mentioned that on an order directing the official liquidator to pay a consolidated remuneration to such appointed auditor for carrying out the requisite investigation and incur the cost of such publication.
You
of
file the report, then I will pass this order.
I'm 14th February, Lordship.
Oh, no, not 14th. 11 February.
11th February. I am grateful, Lordship. Similar prayer, Lordship, in that matter.
Same order, same order.
Thirty.
30, same order.
Lordship, I appear for the one of the secured creditors. We had filed an application which is not listed today, Lordship.
When it will come, you appear. নাম্বারটা নিয়ে নাও, সে নেক্সট দিন দিয়ে দেবে। এটা